Good morning. Good morning. It's Tuesday. It is April 1st. No jokes here because I kind of hate April Fool's Day. And I think a lot of us that are a little neuro spicy don't always love April Fool's Day, or it sneaks up on us and we're like, wait, what? So no jokes here. Well, there will be jokes. There just won't be April Fool's Day jokes because, again, I hate them. So we are going to go to court today for a hearing from Friday in the Karen Reed case, adjacent, because it's about all those text messages. We've got a ton of rulings coming in from the court. I don't think we're going to get through all of them today, but don't worry, we'll get caught up before this case gets started in evidence. They are starting jury selection today. Jury selection is not streamed. If there are hearings that are streamed that are interspersed with jury selection, I will stream those. The best way for you to know and stay in the loop if I do that is to get the Law Nerd app at lawnerd.app.com. We built the Law Nerd app for you. We keep adding things to it. We have lots to come in the Law Nerd app as we get into trial season. So if you want to support the channel, download our free app. A, so we can let you know when we're streaming. B, because it makes us feel like we built something that y'all love. And C, when I can keep you in the loop, then I don't get a million messages on YouTube going, wait, I didn't get notified, because then you feel bad that you didn't get notified and I feel bad that you didn't get notified, and I hate that. So if you want to get notified, well, the only thing we have control over is the app that we built ourselves. So make sure that you get the app because we're working on it. Rolling Along says we need an app calendar. We are working on it. So rolling things out in the app, we are working on it. So I am ready to go. So let's see. Today we're going to go to Friday's court hearing first, then we're going to go to rulings. I will be streaming with the members tomorrow on a members only live in the afternoon. I will not be streaming our normal 11 a.m. time. We've got stuff that we've got to do family-wise, and so it's just your girl is tired. Your girl is tired. So for any of you that are like in that moment in life, I see you, I get you, I'm with you, I'm tired. I am just tired. My kiddo had WGI finals this week up in Kentucky. It was fantastic, but he didn't really get home until about 1 a.m. from finals. So then we were up getting him food and chatting about finals. He performed. I can't even talk about it. I'm still emo. His team they were brilliant. They were so good. I'm so proud of them. It's the biggest group of seniors that we've ever had. And I don't know how parents of seniors do it, but I was just holding people while they cried because it was like, it's my kid's last. And I'm like, yep. You go through so much of parenting with like first. And then they get closer to 18 and you're like, oh shit, I'm still emo. I can't handle it. They were so good. They were just so good. So I loved it. I loved this show. I loved the music. I loved the costumes. I loved everything about this show. Emo. For those of you asking, what is WGI Finals? Winter Guard International. It's a whole situation. Anyway, Winter Guard is lovely. We had a great time. Got home, was up super late. I'm too old to be up till 2 a.m., even if it's just making sure my kid eats food before he goes to bed. And I know my kid's a junior and I'm still in tears. I know. I can't. I'm not going to be broken. I am going to just let it flow. Like, we're just going to let it go. I'm going to be that mom. I'm going to embrace it. I spent years bottling up emotions because like they're not always court appropriate to just sit there and cry. Sometimes I failed at that miserably, but I'm going to be that mom. I'm just going to be crying. So then Ryan Hall, y'all, not his fault, but Ryan Hall, y'all, spends a good chunk of the evening on Sunday talking about where I live. It is never good when Ryan Hall, y'all, is like, whoo, I got questions about where y'all are at. So then I was like on tornado watch and getting my kids out of bed because we actually were close enough to need to be in our safe space. And lots of sirens, lots of lots of weather, lots of hail. All of you all that live in those regions know sometimes it's fine and sometimes it's not. Yes, Carrie B, Squeaky Squirrel says, no, you don't want Ryan Hall talking about your town. Ryan Hall's the weather guy. Yes, and you don't want Ryan Hall talking about where you live. And we're fine. Roof is fine. Everything is fine. We did not get the worst of the hail, but people had like orange size hail, not too far from our house. Just wild. Mari HK says, Ryan Hall, y'all needs to keep your name out of his mouth. It's so funny because I see his chat and his mods are wonderful, but you see his chat and you can feel the stress of people in his live chat being like, what about this? What about this? What about this? I'm like, y'all, if he's not talking about you, be glad. If he is not talking about you, take a deep breath. If he is not talking about you, just look at the trajectory of the storm and see if he's going to talk about you or not. Because if it's not you, it's not you. Be glad it's not you, boo-boo. If he's talking about you going, then you want to be in your safe space. That's what you want to do. Guess who hates a safe space in my house? The cats. Putting cats into a tornado safe space is not their favorite. Is not their favorite. Yeah, there are numerous WGI finals all across this fine country. So it was lovely, but we run into band law-nerds. We scooted in and scooted out, but we had a lot of fun. I have not had enough sleep. So inevitably somebody's going to come in and be like, Emily's spicy today. Just be like, Emily has not slept nearly enough. We're tired. Court is just nonstop courting. That man is nonstop. Sorry, Griffin is in a Hamilton phase, so you're going to hear it from me. But streaming today, we're going to get into it. No streaming tomorrow because I've got doctor's stuff with the kiddo. We're going to do a members only a little bit later in the afternoon. Streaming again Thursday. If stuff pops off and we need to take a look, then we will. For any of you that either Roxy says, I'm now subscribed to Ryan Hall, y'all. Look, if any of you live in areas where you get spinny, swirly weather, or you just enjoy watching weather, I can't recommend it enough. I know there are tons of weather channels. I like the way Ryan runs his channel. I like his entire philosophy is prepared, not scared. He's not going to make people hysterical. He is a very calming presence. His mods do a great job of trying to keep the chat wrangled so there's no misinformation. He brings in storm chasers. If you want to watch people who have the storms like literally on their dash videos, just 10, just 10 out of 10. All the law nerd love for what he does. And he and I are getting into our busy seasons at the same time because it is spring. all the trials happen now because we're out of the slump of winter and winter break, and everybody's trying to get done before like midsummer. So we are in that really big push in court, and then the spring weather is when everything gets spicy with the tornadoes as well. So I haven't even run the intro yet. We're going to run the intro. We're going to go to court. We're going to do all the things, and we're going to start with court videos. Some of you saying there were a little bit of stuff that was aired today. I'll have the mods look for that and see. Miguelina can take a look and see, but we're going to go to Friday's hearing first. So let's roll the intro, and then we're going to ship ourselves up to Boston. Y'all, court season's about to get really, really busy. So for all of you that are like, live court's my favorite, buckle up, because that's exactly what we're going to be doing for, well, weeks and weeks and weeks and weeks. At some point, I'll put up a poll. Once we're done with jury selection, I'll put up a poll as to how many weeks the Karen Reed case will take. For those of you that are new, I do not poll on guilt or innocence. I do not poll on things that are for the jury, but I will poll on how long we think this trial might take once we get through jury selection. Jury selection might take 3 weeks. So we got a minute. And we got some Koberger hearings next week. So next week, we're going to shift gears a little bit and talk about all the motions in limine and Koberger. So don't worry, we're going to get back there too.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
So I'm going to pull up court first from Friday. I think doing court from Friday first and then getting into documents is a good call. And I'm really curious to see what happens. I saw the very beginning of the hearing, but then I was traveling and did not see the rest of it. So it is not a super, super long hearing, which I appreciate, and it is adjacent. Remember, let's do a quick road so far. Wait. Road so far. Let's do a quick road so far. We have the prosecution trying to get to text messages between Karen Reed and Aidan Kearney. I'm going to continue to say it wrong because it is it's in my brain the wrong way, and I'm trying to not, but it's hard to dislodge. So the Commonwealth is trying to get to text messages between the two of them. He has a pending case. So it is regarding the phones taken in his pending case. His phones, text messages between him and Karen Reed. The Commonwealth is saying that they want to use any text messages between the two that relate to a supposed or alleged witness intimidation to show consciousness of guilt. Not to prosecute. We know that a grand jury was impaneled and did not indict on that, but to show, look, if she's trying to get witnesses to not come to court or to not say this or that, if that even exists, then they're trying to get it in to argue she knows that she's guilty and she's doing this because she knows she's guilty. So that's where they're trying to get to. So we saw the last hearing at the end of stream, last week, the week before. They're all running together. So we saw that hearing where you had the Commonwealth arguing to a different judge that they were entitled to all of this, that the other prosecutor has it under that Rule 17. We've also now seen Aidan Kearney, Turtle Boy, asking for a protective order if those are disclosed, which is appropriate if you're disclosing that type of information, that it would be literally for the prosecutor, for the defense on the other side, and that's it. That's not stuff that should be in motions. And I don't think it's much of a stretch to ask for because we've seen protective orders for Proctor's text messages and such. I don't see an issue having a protective order for Turtle Boy's texts that are related to a separate and different case if they're going to be used for that narrow aspect of consciousness of guilt. So this came back on calendar because it seems that some clarification is needed. So between that judge and Brennan, we are going to go to court and take a look at what they have to say. Emily, do you have it pulled up just yet? No. Should you have? Yeah. Well, the intro was playing. What were you doing? I was just bopping along. We were just beat bopping. Just bopping to the intro. Sometimes it happens. Let's make sure that we get the sound good. That's what I wanted to make sure we did. And then we'll go to court and cover that. So let's do a little live court from Friday before we get to all of the rulings. There are so many rulings. So hear ye. Court is now in session from Friday. Miguelina, when you put it in the pinned comment, will you note that it's from Friday? Invariably, somebody's going to stumble across the stream and be like, hey, isn't this from Friday? Yes. Yes, it is. But I was snakes on a plane on Friday. So, all right, let us go to court. We are using the feed with closed caption, but if I do this, I need to modify my size to there we go, to make sure we're not using anyone's copyrighted logos, though using their feed. Let's get dangerous, Shall we? All right. I am optimistic that this starts pretty soon thereafter. So
Make sure your cell phones are off and put away for me, please. Thank you.
correct. That's our hear ye guy. But this court doesn't seem to hear ye. So hear ye. I love it so much. I think the hear ye's are fantastic. Just fantastic. So they said all rise. They're calling to order. You guys are on the Darkwing Duck with me. I know. I can't stop. Can't stop, won't stop.
Judge, this is 22117 and
The clerk is so tall.
23313, the Commonwealth versus.
The clerk is so tall because the clerk, I think that the floor there is a little bit lower than the judge, so you can see over the clerk to the judge. The layout of these courtrooms is trippy to me. It's so wild that the prosecutor's table is like crammed right up against the court reporter and the clerk. The U shape of the courtrooms is so odd to me. The clerk is so damn tall. I'm here for it, but so tall. I was in New York for a YouTube event. Emily, it's not time for story time. We're going to court. I was at a YouTube event, and my friend Marissa said, "Hey, I'm going to the grand opening of a Dave & Buster's, and they're giving us unlimited play cards. Do you want to come?" And I was like, I mean, don't threaten me with a good time. So we end up at the grand opening of the Dave & Buster's, and there's a football player there, and I send a picture of the football player to my husband and some of the people on Team Baker. I'm like, "Look, it's football dude." And they're like, "Emily, that's not football dude. His name's Eli Manning." I'm like, yeah, football dude. But his bodyguard had to be like 6'8", 6'9", because if you're the bodyguard for Eli Manning, you're like so tall. It's so impressive to me. I'm just like, damn, sir. But also I was just trying to get a picture of football dude so that I could send it to my husband, because hilarious. But the bodyguard, just there is no need to clear a path. Like the bodyguard can just see everyone, because again, if you're bodyguard for football players, you also need to be massive. He could see everything. I got to play Deal or No Deal. I had the most fun. I was terrible at it. I had the most fun. I don't think I've ever been to a Dave & Buster's where I'm not running around with my kids. So to get to like play on my own with the adults and be like, I want to play Deal or No Deal. So much fun. They have new games. We'll talk about it on members only. There's like a human claw machine. I took videos. It was wild. Let's go to court. But the clerk, we love it. We love it. Look, Emily, you played water polo. Has it given you a complete complex about your height or relative lack thereof? Yes. Yes, it has. Yes, it has. Yes, indeed. So it's a sport where being tall helps. Water polo, volleyball, these things.
This is Karen Reed, and separately the Commonwealth versus Aidan Kearney. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please. I need to plug.
The judge is like, can we pause? You guys are asking, is this a new judge? This is the judge that's filling in on this matter. But yes, this is a different judge, but not a new judge.
Because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
Which is Reed's
That
case
was
number.
also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you.
Thank you, Mr. Clerk. Oh, for those of you in the chat asking about Eli Manning, Eli's not super tall. His bodyguard was super tall. Eli's not super tall. He's tall, but he's not like, holy shit, that guy's tall. Where'd my hand lotion go? Emily, every stream? Yep, every stream. So these are the prosecutor from Turtle Boy's case, and then Brennan, the prosecutor from Reed's case. They are both specially assigned prosecutors. This case is just all the special prosecutors all over the place. Let's zoom while they are trying to get the Zoom parties in.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth, relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm a special prosecutor on the Aidan Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
So it's a Rule 17 motion between the two special
Hello, Your Honor.
prosecutors on the different
Timothy Bradel
cases.
for Aidan Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr.
Hey, Matt
Kearney.
Bond.
Good morning, Your Honor.
Good morning, Attorney Bradel.
And good morning, Judge. Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
I'm glad everyone's present via Zoom.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed?
There are closed captions. They should be up.
Doesn't
Thank
seem
you,
so.
Casey, for
Okay.
pointing it out. They should
Folks,
be on.
we are
I had
here
had them
on two related matters
Apologies.
this morning.
I didn't
As
even
an
notice I was
initial
looking at
matter,
all those
we are
streaming
here
things.
because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17.
The court's order was regarding turning over text messages, and it was very narrowly constructed. It was specifically turning over text messages from Turtle Boy's phone searches, texts to Karen Reed or between him and Karen Reed regarding witness intimidation. That was the narrowness of the order. Let's see what the confusion is, shall we? Emily, get your notebook. You're going to need it. I know.
Motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney.
The protective order is fair.
Hear that as well. So, with regard to my order, let me start by saying this.
What are y'all confused about?
Going back to Attorney Brennan's affidavit filed in this case on
Brennan,
March
what'd
5th,
you do?
2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed.
Uh-oh, Brennan. Here's the thing. We've seen the Reed attorneys say in other documents that there was no mutual defense agreement. So, a mutual defense agreement is something that we saw between Baldwin's lawyers and the lawyers for the armorer in the Russ case, Hannah Gutierrez, where the lawyers, with the approval of their clients, had written waivers from their clients to share beneficial information with one another. So it can expand attorney-client privilege to different conversations, but also it allows the defense attorneys to freely share information without going to their client every single time and saying, hey, can I share this? Hey, can I share that? So these are signed, essentially, waivers where each defendant says, I understand that you're sharing information about my case. I understand who you're sharing it with, and I understand for what purpose. It's a very specific thing, but it is a formal document. But we've seen in the Reed case and other hearings where, especially when they were arguing about Attorney Betterow coming into the case, that there was no mutual defense agreement, that there was no understanding between the defense teams that they could openly and freely share information. So if Brennan is representing that, it's not what we've seen, unless what's being represented by all of the defense attorneys is not true. But Brennan doesn't have a great track record with me, and this judge already seems pissed. This body language is not happy body language. This is not happy judge. This is mad judge face. I'm going to back this up a little and let the judge finish. I'm going to let you finish because I knew there'd be a lot of questions about the mutual defense, but let's continue.
Okay. Folks,
Let's continue.
We are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week.
On the basis
do
of
any
that
of the
statement.
3 categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these 3 articulated categories be produced. However,
oh dear.
Subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that 1, there are, in fact, a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged.
What the fuck, guys?
My order did not specifically exclude from production.
Hey guys, what the fuck? What the fuck, y'all? The special prosecutor in Reed's case said any communications between Turtle Boy and Reed's attorneys would be privileged, and I'm not seeking those. And the special prosecutor in Kearney's case said, no, those aren't privileged because there's no mutual defense agreement. So you have 2 prosecutors on 2 different cases arguing 2 different ways about the same texts. Now, I think that with regard to no mutual defense agreements, the text messages, and it seems like there are such text messages, the text messages between Turtle Boy and any of Reed's attorneys are outside the scope of what the court ordered. The court said texts between Reed and Turtle Boy, period. Not Reed and Reed's representatives, not Reed and Reed's associates, Reed and Turtle Boy, period. So I don't think in the Reed case, you get texts between Turtle Boy and the attorneys, because what the attorneys say can't necessarily go to consciousness of guilt. So I think it's a sub issue. What happens in Turtle Boy's case is completely separate. Oh boy. So I think the judge's order was really clear. Is it that now they want more? Let's find out.
Communications between Mr. Kearney and Ms. Reed's counsel, because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan.
What the fuck?
Respectfully, did I misunderstand you, or perhaps vice versa?
The court was generous
in other
in
words,
that.
I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. May I?
Yes, you may.
I think there are 2 separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor
You
asked
said they
the
were
question,
privileged.
I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filing.
Did you really?
Is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that
If-
wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
When the court said, I asked you this, the answer is not if you said that. That's a no. That's a no for the judge. The judge is like, I love that this judge is going to make sure that everyone's on the same page to get to the answer. He's not going to let him just keep going. He's going to be like, no, I said. And the attorney's response to this judge is different. It's very different because this judge gives them no room to wiggle.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it.
I think
But
that's
was trying to be
accurate.
protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado, Mr. Betterow.
Okay,
I did
well, we
not-
all agreed, counsel, that those in fact would be privileged communications.
There's not
without
even a question about
so
that.
Let's turn
So
to,
why
if
would we be
if you
asking about
would,
that?
The second issue.
That's decided.
Which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
I was talking about it because you were talking about
I
it.
do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out.
Then why'd you
that
talk
in
about
an
mutual
earlier
defense?
hearing, and I have the transcript of it. It was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Brado. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then Mr. Brado responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by
That
the
doesn't
court,
say there's
Mr.
a.
Brado answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long.
So, Brennan, when you quoted that, you left out the we don't have an agreement, there's a long-term implicit agreement. You left out the first part of the sentence from what the court read in court. What the court read in court was what you quoted, but you left out the first part. Brennan, you're the prosecutor in this situation. You don't get to splice sentences like a Bravo editor and then give a wink and a nod. You're in court. There's no shady edits. Put in the whole sentence. The sentence is, there's no mutual defense agreement. And it doesn't even make sense. It doesn't even make sense that he would be arguing that there is a mutual defense agreement because it could forestall him getting to the things that he wants to get to. There's no point. Why splice it for no reason? We have heard that there's no mutual defense agreement. So an implicit agreement is not the same. We have an understanding. Well, that's not the same. And if it looked like Reed and Turtleboy at one point were going to be co-defendants, then it's every man for themselves generally. Sometimes co-defendants will team up. Sometimes co-defendants will be like, other dude did it. Not me, that guy.
Long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two.
Then why is it
inevitably? And
your
after
motion?
that, Attorney Betterow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yannetti's
I like this, Judge.
sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly.
Ding, ding, ding.
And so I think I had the assumption there was no
But you represented it as if there was. Oh, I love this judge. This judge is like, but you said. But you said. Emily, why do you like this judge so much? Well, he matches the energy that I appreciate. Like, we're not getting past this point until this point's resolved. I'm not going to let you keep going. We're resolving this point, but you said. But you said this, but you said this, but you said that. Look, this is not a helpful argument style in relationship. I'm just going to give you that. But in court, it works really well. Sometimes it works well with your kids. But you said. Spouses don't love this. I speak from experience sometimes when Dr. B is like, we're not in court. And I'm like, but you said this. Can you explain? So Brennan's like, oh, okay. Okay. The misrepresentations are not going to stand with this judge.
That there was no joint defense privilege between...
Here, I'm going to back up to the judge and let his full sentence go with him saying, but Yannetti's sworn affidavit says.
Docket 549 on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important
Then
pleadings.
why did you say there was an implicit agreement without quoting the entire sentence?
But those pleadings...
You don't even
were
make
filed
sense.
publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth's pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823 when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've
court's
reached
like,
a point
shut
where
up.
I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint.
So the judge ruled that conversations between Karen Reed and Aidan Kearney were getting turned over. And now the judge has called everybody back into court saying, hey, why are y'all confused? And the prosecution's like, well, there might also be conversations between Karen Reed's attorneys and Turtle Boy, Aidan Kearney. And in the filings from the Commonwealth, Brennan, he said, and he said on the record, that any conversations between counsel and Turtle Boy would be privileged. And he's walking that back saying, no, I meant between Turtle Boy and his counsel, not Turtle Boy and Reed's counsel. But it sure seemed to me in court he was taking the position that there was a mutual defense agreement and that was privileged. And as I said earlier in stream, the mutual defense is an agreement between the defense teams, which can expand privilege. Because if everybody's working together, it can expand privilege over communications potentially. And the court's like, well, now I got to figure out this pile of dog shit before we even get to what gets turned over, because now you've changed the game. And the two prosecutors were arguing different sides of the issue. It seemed that Brennan was arguing, I don't want anything between Reed's attorneys and Turtle Boy. And the other prosecutor, Cosgrove, was like, that's not accurate. Those aren't privileged. And if a reporter talks to a defense attorney, that's not privileged unless there's a reporter privilege, right? But when you've got a situation where there might be co-defendants and a mutual defense agreement, because some of this is talking about the time period before the grand jury didn't indict Reed and Turtle Boy together, there might be issues of privilege there. So now the court is like, we went from a pretty clean cut issue of text between A and B to an expanded issue. And I have to wonder if some of this is based on Turtle Boy's postings on Twitter, because he posted quite a lot. Hey, all my conversations with Karen Reed were on Signal. So there aren't any. So enjoy that. Like, there are no texts for you to get between me and Karen Reed. I just wonder if some of this is the Commonwealth saying, oh, maybe there's not conversations directly between Turtle Boy and Reed, and we need to expand the scope, broaden the net. I wonder. That's pure speculation on my part. I just have to wonder, because he keeps saying, I've never seen any of these. I don't know what's there. I don't know what's not there. Well, the conversation on social, which we know Brennan's paying attention to, indicates that there's nothing there. Is that why he's trying to expand the scope of what he's asking for? Because the judge was real clear. I mean, I don't know how long Brennan's been doing this. I have to guess it's longer than me. And I look old and tired. But I have to guess Brennan's been doing this longer than me. Like, you're not new. This gamesmanship pisses me off. Like, don't act new when you're not new. It's inexcusable.
Defense
Oh, so now they're turning to Turtle Boy's lawyer to be like, what say you?
agreement and related privilege to communications.
Thank you, Chad. I
between
truly wasn't
yourself
fishing for compliments, but I
and
appreciate you.
attorneys for Ms. Reed, such
I
that
feel old
I
and
need
tired.
to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago,
Because there's not a
we
privilege.
had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So
Okay.
we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed.
This is one of
So why
Turtle
would
Boy's attorneys speaking.
communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Reed.
I'll stop you
Nothing
right there,
about
Attorney Bradle, because you
lawyers or
raised
third parties.
an excellent point, and that point being is that
Your order
point
was narrow.
From the court's perspective, is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we are privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or
Right, it was a
text
very
or
narrow
emails
order.
that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court.
All right, I'm cutting off Turtle Boy's lawyer for a second there, because what he said that was important and instructive for us is that Cosgrove, the special district attorney in the Turtle Boy case, filed a motion that's all impounded. It's under seal. And I think Cosgrove did that so that Brennan's misstatements didn't impact the case for Cosgrove, and Cosgrove was saying, well, I'm the one that's responsible for turning these over. So I want to make sure that I'm turning things over that are in line with the court's order. And Turtle Boy's attorney is saying what Turtle Boy had posted on social, which is there's nothing that's responsive. So the judge's order is narrowly on point, and because not a fishing expedition, the judge's order is narrowly on point. If there's anything responsive to this, turn it over. If not, not. So best of luck. And the attorney is confirming there is nothing that's responsive. There are no conversations between Karen Reed and Turtle Boy about witness intimidation. And even in witness intimidation cases that I have had, nobody talks about it like that. There's no conversation where somebody says, let's intimidate this witness. That doesn't happen. It's all subtler than that. I mean, not so subtle that it doesn't get prosecuted, because I've had a couple witness intimidation cases. They really piss me off. But they're subtler than that. No one says, let's go intimidate this witness so they don't testify. That might be what's behind it, but nobody says those words, or at least not in my experience. Somebody somewhere might.
Court ex parte.
It'd be dumb.
So I can only imagine what's in that, and we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Kearney and Reed, not third parties that might
The court's
or may
worried
not
about
have
group
spoken
texts.
to Reed.
And that's fair.
And these are things that are privileged among that team. So this isn't a
Oh,
can
no,
of
no,
worms
no,
that
no,
the
no,
court did not
counsel.
open by any stretch.
If there are group texts with Karen Reed, her attorneys, and Turtle Boy, those are not privileged. If there is not a mutual defense agreement, which it seems that there is not, those are not privileged. The second that a third party is in that text group, those are not privileged communications. So I disagree with that. If you bring in a third party, the privilege is gone. So those aren't privileged. Text between Karen Reed and her attorneys on a group text, if it's just her attorneys, that can be privileged.
And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate. In particular, because
So Cosgrove's the one who did it.
Prosecutors are in different positions due to a conflict of interest, an express conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank you.
So the fact that
Attorney Breda, I'm gonna ask you to pause for a moment.
Breda's
and
like,
I'm gonna hear from
no dice.
Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys.
How?
How would those be swept in when the order specifically calls for
A and B.
communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information.
Turtle Boy's attorney just said that there are no communications between Reed and Turtle Boy. So the DA who has all these communications, or the special prosecutor who has all these communications, is saying to turn over communications between Reed and Turtle Boy would necessarily include communications between Jackson and Turtle Boy, Yannetti and Turtle Boy, and Reed and Turtle Boy, which might be group text or not group text. But he's saying, look, Reed's attorneys are acting on behalf of Reed, but the thrust of the argument from Brennan is that these go to consciousness of guilt. So Cosgrove is trying to expand the scope to give it to Brennan. Okay.
To Mr. Kearney, I think that they act together in that respect, Your Honor.
Thank you.
But it doesn't go to
Attorney
state of
Cosgrove.
mind.
Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between defendant Reed and Kearney and defendant Kearney concerning those three areas of inquiry.
The judge is
So,
like, I said what the
I
fuck
am
I said.
Specifically,
It was crystal clear.
requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
A and B. That's it. Turn those over. Nothing more. That's it. Those two. That's all.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to
Done.
hear any further on this. The order is clear on its face, and
We
I
need
expect
not
the
tread
parties to
any
comply
further.
with it. I'd like to turn now to the issue of the motion for protective order from
The judge is like, I could not have been more clear. Do it. I said conversations between Reed and Kearney. That's all. Turn those over. Now, there's a whole separate side quest of whether they need a Rule 17 to share this information or not. I'm actually glad that Brennan had the foresight to say, I'm going to have a court order. I'm not going to just ask the other prosecutor for this. There are special prosecutors all over the place in this because of conflicts with the DA's office. I think Brennan did the right thing by taking this to the judge and saying, I'm not just going to go ask. I'm not just going to go get this information from a different case file. I think that was the appropriate thing to do. So narrowing it down, the judge is like, I gave you an order. The order is clear. How are you confused? Everyone in the chat said it. Did I stutter? What don't you understand? Turn over just what I said. And I imagine Cosgrove knows that there's not much there, but I'm here for it. Look, if you want to use it for consciousness of guilt, you can't use what her attorneys were saying for consciousness of guilt. You might be able to use it for something different in a different type of case, but not in this case. So that's it. All right, let's continue.
Mr. Brado. So I'll hear you on this, appreciating that I have had the opportunity to review the attachments.
I think the protective order makes
And
sense.
certainly the basis for this, but I'm not, I'll preview where I end up.
If everybody else's texts are
Attorney
protected,
Brado.
why
I'm
wouldn't
not
these
quite
be?
clear
Sure.
on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. I am not, this is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks
Trial would go so much
that
faster
the
with this
court
judge.
order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th.
Okay, I see lots
but
of
you've-
confusion in the chat, and I don't really think it's confusion. I think it is deep rooted wishful thinking. Chat, I am with you. This is the judge just handling this matter. This judge is just handling this matter in the Reed case. This is not a new judge for the Reed case. This is not a different judge for the Reed case. This judge is just handling the matter of the text messages. That is it. That is it. Chat, I hear you. Well, Emily, we're good. You're not going to be able to say this without being spicy. Just leave it alone. But I prefer a judge that is consistent, clear, and is like, no, counsel, this, and just pins it right down and moves on. It keeps everybody on a more equal footing, and I appreciate it. So I like this judge's demeanor quite a lot. But no, this judge is just handling this matter. I'm sorry, y'all. I know. Look, man, it's nice to see, but this is not the judge in our case.
Specifically requested that the court order that police and prosecutors
So now we're talking about the protective order.
refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
They are, Your Honor. Judge Kearney specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made
There's a
that
gag order.
specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibits, Judge, these outside people are receiving information that in no way would a prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Kearney's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's...
Brennan has taken on Lally's posture at the table. He's just like, okay. The defense attorney is asking for a protective order. The court's comment with, am I just adding a belt to suspenders, is this even needed? Why are we doing this? There's already a gag order, but a protective order can go further than the gag order. It's information that shouldn't be shared, but the defense is saying they have concerns that it will be, can be, and is being shared. Even if it's not being shared by the prosecutors, could it be shared by law enforcement? And a protective order can make sure that no one on the prosecution's team, which includes law enforcement, is subject to that protective order vis-a-vis just the attorneys. So
focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Kearney. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order.
They're asking for
guess
more.
What? Those, Judge Cannoni's order didn't work either, based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these three people must
And there's
stay
more you
away.
can do if it's violated.
And a general order as well as part two is my part two. And to the extent that those
The gag order is
people
pretty strong.
have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking.
That's
Judge.
different.
Thank you.
That's
Thank you,
separate and
Attorney
apart
Brito.
from
Attorney,
this.
Little Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations.
Oh, Yannetti's not happy. He's like, we take no position, but we're pissed.
Cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his
So it's
prosecution.
not before the court.
You know, again, detailed.
So it's not filed in this case.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, ADA Cosgrove, Special ADA Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by
That are
the Rule
responsive.
17 motion?
Actually responsive.
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank
That's
you.
today-
We'll expect
yesterday.
something by close of business Monday, and if you encounter any difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations
So that would have been
we need to make.
yesterday.
Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
So they can fix it and then
Thank
give
you
it
very
over
much,
to
Attorney
Brennan.
Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no
The judge was done. The judge was done. The judge was done. They are wrapping up. The judge is done. What do you need to clarify? Today's not going well for you. What more do you need to say? Oh boy.
conversations between Special Prosecutor Cosgrove and I about.
I'm going to back this up because I lost the court is so done. And he's like, can I just, for the record?
Attorney Brennan.
Your Honor, just for clarity of the
Court's
record,
like,
I'll be
what?
brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed the Rule 17, so there is a clear public record that we're beyond reproach.
Okay.
Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear,
That was directed at Cosgrove, not
I
you.
filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Oh, he wants to fight with
Understood.
Yannetti.
Thank you, Attorney Brennan. Thank you, Attorney Cosgrove. Thank you, counsel. No, we are adjourning the hearing now. Thank you, counsel.
Yannetti's like, wait. And it's like, no, this is not Judge Cannoni. We're not going back and forth and back and forth and back and forth. That was not needed at all.
Goodbye.
I'm going to make sure we're actually done. I'm going to watch the judge get off the bench. Good Lord. Just the judge is like, we're fucking done. Nobody needs to make a record. The judge is not holding anything against anybody. We are done. We're done. Just, I'll make my order on the protective order. We're done. So we are, let's swoop real quick because we are at the end of this hearing and we have a decision to make as we have a decision to make as a group. So let's try to summarize this. Well, it seems that the judge's crystal clear order that the only thing turned over from Special Prosecutor Cosgrove, who is prosecuting the case against Turtle Boy, to Attorney Brennan, that only conversations between Reed and Kearney get turned over, was not specifically clear to the prosecutor Cosgrove on the Kearney case, who said, well, that loops in text messages between Attorney Yannetti and Attorney Jackson and Turtle Boy and Karen Reed and all of them in Turtle Boy. And the court said, no. If this is being used for consciousness of guilt, my order said conversations between Reed and Kearney, period. Not Reed's attorneys and Kearney, just Reed and Kearney. Now, if there are text messages where Reed and Kearney are texting back and forth, then the conversation between the two of them is what would get turned over, even if other people might be on those text threads. But the court said this is a narrow ruling because it is what matches what is asked for by ADA Brennan, or Special Prosecutor Brennan, who asked for conversations between the two for consciousness of guilt. Cosgrove, it seems, took an expanded interpretation of that, saying that the attorneys for Reed were acting on her behalf. That isn't going to go to Reed's state of mind, though, because you would have to violate attorney-client privilege to try to prove the conversations between Reed and her attorneys to prove it is acting out her state of mind, and you can't get to that. It's just not going to happen. So the court said, I said what I said, and then they discussed a protective order, which we will see if that gets granted or not. It may have already been, and I have not seen it on the record yet, but we will see what happens with that protective order. Now we need to make a decision as a group. There are two fairly substantial orders from the court that I wanted to go over with y'all. I went over the new lawyer / alternative juror on the Emily Show podcast yesterday. We went over the First Circuit ruling on the Emily Show podcast yesterday. If you've not caught that, it lives on a different YouTube channel. I send it out in the app. I will link it in the my community posts later. That lives on the Quick Bits channel, because this is the live stream channel, just to keep everything easy peasy and clear. And in theory, it's supposed to be shorter. In practicality, it almost never is. But we have two big rulings that I put in the thumbnail that we were going to go over today. The court ruled about third-party culprit, and the court ruled about the defense expert. But all of you have let me know that there was about an hour of hearing aired this morning before they started picking a jury. So I don't think I can do all three things: the orders, another hearing, and this hearing in entirety. So I'm going to put up a poll. If we want to do the hearing from this morning, we can, and I can skim the other orders, or we can do the orders on Thursday. So I'm going to start a poll. Let's see. The hearing, the orders. So the options are the hearing, the orders, and then the hearing, skim the orders. So I'm putting in a poll. I'm going to ask you guys what you want to do. We go to the court. We go to the court of public opinion. All of you are saying the morning hearing. All of you are like the hearing, the hearing, the hearing, the hearing. The hearing's like an hour long, so we have time to cover it. But a lot of you want to go over the hearing and maybe skim the orders. Let me pull up the order with the defense expert first, and we'll start skimming that along and let you guys vote. There's over 15,000 of you here. We'll change the title if we need to, but let's skim the orders and then we can go to the hearing. And if we need to do in-depth on the orders, we will do that. So let's see, right now we are at 46% skim the orders, do the hearing. So the chat, there's 15,000 of you here and only 1,000 of you have voted. So if you guys want to vote, throw your votes in now. A lot of you are saying the hearing was not much this morning. I know the hearing was just the intro to the jury, but again, we're putting it up to the chat. I'll pull up the first order with the defense, with the defense expert. We'll do that one first while I let you guys vote, because this one we can skim either way. So let's do that. All right. So right now we are going to switch and take a look at the court's decision on the Commonwealth's motion in limine to exclude the defense expert in essentially policing. This is something that is unusual for me. It is something that's very common in other jurisdictions. So it's weird to me that it's weird, if that makes sense, because we're taking a look at, can you bring in an expert to say police investigations should do this, this, that? Again, it's weird to me that it's weird because it's so common in other jurisdictions. This seems to be weird in Massachusetts. You guys, if we've said anything about judges and how they make decisions, what have we said? What have we said? What have we said? Don't be weird. Judges don't want to do anything weird. They don't want to do weird stuff. They don't. So we let's take a look at this. Judges don't want to be weird. That's like the number one rule. So this is from, I think this came out yesterday. Hold on, let me skim to the end. Yeah, the 31st, yesterday. It's a pretty quick order, so we're gonna zoom over it real quick. The court says an expert may, when appropriate, be used to support a Bowden defense on matters beyond the common knowledge of jurors. Again, this makes sense to me that you might want, Miguelina says people want to revote now that they know that the hearing is just on the jury questionnaires. Okay, we can do that. We can do that. We'll do another vote. Fair enough, chat. Fair enough. Fair enough. We'll give you a new poll. What should we do next? Hearing? No. Let's put in skim the hearing. Skim the orders. Skim. Zoom. Skim the hearing, skim the orders, cover the third-party defense order, skim the rest. All right. So we've got skim the hearing, skim the orders, cover the third-party defense order, and skim the rest. Those are our three options, because that seems to be what you guys are asking. I'm not giving a third option. Why won't it let me just not give another option? There we go. All right. Let's start the poll. Oh, skim. Oh, because let's see, because my question was too long. Let's see, third-party defense. There we go. All right, the options are skim the hearing, skim the orders, third-party defense, then skim the other two, which means we'll probably put the hearing on a faster speed and zoom. All right, let's skim this order. So, brevity, EDB. I know it's too long of a question. Here's where I'm at with the Bowden defense, just so we're all like on what the Bowden defense is. I think this is the defense's strongest argument. Look, I am not the trial dog in this fight. I am not the one sitting there making the trial strategy. I am not the one who has to make these decisions. I think the Bowden defense is a really strong defense for them. The Bowden defense being, look, the police investigation was not it. The police should have investigated these other leads. They should have done things differently. And because they didn't do things differently, the defense is essentially, you can't rely on this defense. I think this is their strongest avenue. It doesn't require jurors to be on board with a lot of people being involved in fuckery. It can let the jurors say, you know what, there's a lot of incompetence going around here. I'm not willing to blame on malice what can be blamed on incompetence. Maybe Proctor was malicious. Maybe some of the other witness statements don't make sense. Maybe or maybe not they were malicious. I don't have to decide that. I can decide that this police investigation wasn't it. And because of that, I can't be sure beyond a reasonable doubt. I think it's a good avenue for the defense. That's the Bowden defense, that the investigation didn't do what it should have done. That is me really narrowing it down. An expert may, when appropriate, be used to support a Bowden defense on matters beyond common knowledge of jurors. I think policing is generally beyond common knowledge of jurors. People do not understand policing. People don't understand all of what should or could go into an investigation, and it makes it more clear. If you have someone saying, it's better to do this, the policies and procedures of the department are that. The court cites case law saying, considering whether counsel's failure to use a forensic expert to testify about gunpowder residue and measurement of bullet trajectories deprived the defense or defendant of a chance to assert a Bowden defense. Quote, the role of expert testimony is to assist jurors in interpreting evidence that lies outside their common expertise. This can be anything that lies outside common expertise. Right? Do any of you love a good fan theory? Some people are experts. Some people aren't. You can use an expert in just about any area that's relevant to a case that's outside the common knowledge of the average juror. I think policing falls into it. The court says the first foundational element that the proponent of expert testimony must establish is that the testimony will assist the trier of fact to understand the evidence or to determine a fact and issue. That's what an expert's for. It can be everything. It can be anything if it's not common knowledge. The court goes on to say, in support of her Bowden defense, the defendant here seeks to admit expert testimony from Michael Easter, a retired agent of the FBI. The FBI. To opine on law enforcement failure to adhere to standard investigative policies and protocols in this case. You know how I feel about this motion. Then again, Jackson and I practiced in the same jurisdiction, and for a while we worked in the same office. So it doesn't surprise me that we're on the same page on this, because this is commonplace in California. This isn't unusual at all. It goes on to say, more specifically, Easter's expert report indicates that he will testify that the investigation in this case was not reliable due to the lack of a secured crime scene, absence of a detailed crime scene log or evidence chain of custody, the failure to separate witnesses, and the premature categorization of individuals as witnesses. I agree with most of that. Yeah. And I think you need someone to come in and say, this is what a chain of custody should look like. This is how it should be done. Stuff shouldn't go missing without a chain of custody for weeks and weeks and weeks. I don't think he can state that the investigation is not reliable. I don't think he can give that expert opinion. I think the opinion would have to be narrowed, because that's the jury's determination. I think the opinion would have to be narrowed to proper policies and protocols were not followed, or standard policies and protocols were not followed in this case. I think an expert can give that opinion. His opinion goes too far, but I think that can be narrowed down. That's not what the court does here, but I think the court could have done that. They go on to say the court cannot find, nor has the defense counsel cited one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation, footnote 1. The defendant cites Commonwealth versus Wood, where the Supreme Judicial Court noted that, quote, defense counsel, through cross-examination and the calling of its own expert, extensively challenged the adequacy of the forensic investigation conducted by police. The court acknowledges that some forensic matters are beyond the common knowledge of jurors and therefore appropriately explained by expert testimony. This is not what the defendant is seeking to present through Easter's testimony. I see why they use that case because it's akin to one another. I don't understand. I don't know the policies and procedures of Starbucks. It doesn't stop me from going there like 3 times a week, but I've never worked there. I don't know. I don't know the ins and outs of policies and procedures for accounting. That would be beyond my common knowledge. I think for a lot of people, it would be beyond their common knowledge. And I think policing falls into that. It is a profession that has its own rules that are different. Military is different. So I don't get why this is weird, but the court says that this is weird. The court says the court cannot find, nor has defense cited, one Massachusetts case where an expert was permitted to opine on the general competency of the police investigation. I think they can opine that they didn't follow policies and procedures. Sorry, my hair is bugging me. The lack of authority suggests that during all the jury trials where the defense has been inadequate police investigation based on Bowden, expert testimony has not been needed for the jury to be able to evaluate the reliability of the Commonwealth's case and whether any failures in investigatory steps are sufficient to create a reasonable doubt of the defendant's guilt. I think I just disagree. It goes on to say Easter's proposed testimony concerns basic aspects of police investigation, which are within the common knowledge of a layperson. I just disagree. I just disagree. And it's not going to change my mind. I just disagree. And I don't know if doing this through cross-examination is going to be sufficient, but they're going to have to try. Through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures. My concern is that no one follows the standard practices and procedures. So what they're saying is just fine, is in fact not. But if the court is saying this is not done in their jurisdiction, then the court's ruling is consistent with the rest of the jurisdiction, and judges don't do things that are weird. And it seems here, though it is odd to me, that the different thing would be allowing this type of an expert. But if everyone knew what proper protocol and procedure was, would we be here? And then if you don't trust the witnesses, which witness is going to tell you how it should be done? Because everyone's going to say, I don't know. Like the Canton PD officers were asked about some of this and were like, I don't know, that's not my job. Like everybody was like, not my job. Not my job. That's not my job. Who are you going to question? Proctor? Hey, isn't it proper procedure to have like a chain of custody log? So why didn't you do it? Is that who you have to cross-examine about this? Proctor? Really? Buchanan? I don't know. I just disagree. But it doesn't mean under the law of the land the judge is wrong. I don't have to like it to understand that the judge is saying this isn't what we do here. Maybe they should. But if this is not done in Massachusetts, if this is not an area that they find appropriate for expert testimony, the judge is being consistent with the law of the land. Even though it is different for me, I am not a Massachusetts attorney. So, don't have to like it to understand it. The court goes on to cite case law that says Bowdoin defense supported by testimony elicited from police investigator that he did not conduct criminal history check on third party, waited a week to interview him, and conducted interview for only 10 minutes. Reports would have been admissible to show that the police were on notice of third party as a potential suspect, but not that he was investigated. So the court is citing a lot of case law saying this is done in our jurisdiction through cross-examination. The court finds that expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects. So you can argue it, you can cross-examine on it, you're not forestalled from pointing it out, but you can't bring in an expert to make the ultimate conclusion. They go on to say the defendant is undoubtedly permitted to pursue a Bowdoin defense, and the court will give the jury a Bowdoin instruction if requested. However, jurors are perfectly qualified to evaluate the adequacy of the police investigation in this case without the assistance of an expert. So the court said, look, the jury doesn't need an expert to help. And maybe that's true. Maybe a jury can look at this particular case and go, okay, look, stop and shop bags, solo cups, no chain of custody. That's not okay. That's not okay. Calling the defendant a whack job, see you next Tuesday, and commenting on her ass? No, this is not what's supposed to happen. Maybe it is just within the purview of the jury to just go, this is so fucking bad. Everyone can see that it's bad. Nobody thinks this investigation is good. You don't need an expert. So we'll see. But the judges said the Bowdoin defense will give an instruction on the Bowdoin defense. You can cross-examine for the Bowdoin defense. You can argue for the Bowdoin defense. And I think they should. I think this is the defense they should focus on. We'll see what they do. All right. I disagree. But again, my point of view on this comes from a jurisdiction where this is common practice. Cancel whatever device is happening. Stop it. My devices are like, no, we're going to play some Sum 41. Well, I would love to rock out with Sum 41 to all of you. I don't think the copyright gods would appreciate it. So they still get to go forward with this defense. They don't get to bring in an expert about it. We'll see. We'll see what happens. It's going to be interesting seeing which law enforcement they choose to use on cross-examination to highlight this. And they can argue it. I hope they focus on this. This is a simpler defense. It is much easier for people to understand. And it's, a lot of you are asking, is this an appealable issue? If Karen Reed's convicted, everything becomes an appealable issue. This doesn't seem like the most persuasive because this is not regularly done. So when courts have discretion, and the court has discretion here, and the court does what all the other courts have always done, it's rare that the appellate court is going to say, nah, you should have allowed that. Sometimes they will because they want to change the law. I don't know if that's the case here. Let's take a look at the other defense. What you guys have said in the poll is you would like to go over the third-party defense more and then skim the hearing from the morning. So let's do that, law nerds. Motion granted. We are going to go ahead and go through the third-party defense ruling from the court. And we'll talk a little bit about the nuances between Bowdoin and third-party culprit. They are under the same umbrella, but they are not the same. Third-party culprit it's not this defendant, it's that person. The Bowdoin defense focuses on the police should have investigated more these potential individuals. They should have investigated witnesses separately. They shouldn't have just decided all the witnesses were witnesses. They should have been like, who's in the house and who knows what. The Bowdoin defense really focuses on what police did or did not do. third party culprit focuses on literally, I didn't do this thing, that person did the thing. Different. You know my feelings on the Bowden defense. Let's take a look at this decision on third party culprit, and then we'll zoom at maybe 1.25 through the morning hearing. Emily, have you been zooming through stuff all week? Yes. Why? Well, my continuing legal education was due, and I had California changed all the requirements. Any California lawyers in the chat? California changed a bunch of requirements. Story time, real quick. California added a bunch of requirements. Some of these are direct result of all the Tom Girardi stuff that happened in California, which is not a me issue because I don't have attorney-client trust funds and stuff like that. That's not the type of work I ever did. It's not the type I wanted to do ever. But California added a bunch of other stuff like competency in technology. Do you know what one of the biggest issues they were talking about? This is maybe too inside baseball, but we're going to talk about it more. With the inside baseball of it all, one of the biggest issues they talked about was lawyers doing research on jurors on LinkedIn and jurors being able to see who's looking at their profile on LinkedIn. Like, this is one of the technological competency areas that they were talking about quite a lot in the legal education I was going through. And I was like, so lawyers are out here in trial going through jurors' LinkedIn profiles and literally getting just caught on it and being like, why is this lawyer looking at my profile? And reminding lawyers that, hey, people who pay for their LinkedIn profiles can see everyone that's looked at their profile. Also, you're not allowed to friend people. They also gave this wild example of jury selection, and the lecturers that I enjoyed from this MCLE series, I always like teaching through wild stories. I love that they did the same thing and went and found some wild stories to teach from and case law where stuff had gone sideways. They were in jury selection, and one of the lawyers was skimming people's Facebook pages and you're not allowed to have contact with the jurors, but friending a juror counts as contact. Looking at their profile where they're sent a notification that you're the one looking at their profile can count as contact. The level of jury research, particularly defense firms and then firms in the civil sector do, is quite extensive. So if you are on that type of jury, they are looking at all of your shit if it's public. I'm not saying that if you are on a jury or perspective on a jury in a high profile civil case that you want to make sure that your shit's maybe not public for a couple of weeks or a month or whatever, but they can't get to private Instagram accounts, Twitter accounts, Facebook accounts. They can only get to publicly accessible information. So just saying. Also, they reminded the lawyers that if you are anonymous on LinkedIn and scroll and stuff, when you go not anonymous, then it still shows up, which I actually didn't know. I don't use LinkedIn very often, so I had no idea, but good to know. So there's a juror going through jury selection, and some associate at the firm is going through and doing the juror research. And a lot of courts do not give you the jury list until day of, so you can't do this in advance. They're doing this in real time, like giving it to someone on their team to start looking through it, and is going through on Facebook looking at this juror and accidentally friends one of the jurors. And the juror sees it and says to the court, well, I don't know anyone on this case, but this lawyer friended me and we have mutual friends. And so the lawyer gets kicked off, or the juror gets kicked off. The lawyer has to explain. Later in the day, the juror posts on Facebook, found the best way to get off of jury duty. If you friend one of the lawyers on Facebook on social media and the court knows about it, you'll immediately get kicked off of jury duty. The court found the juror in contempt. Like, shit went sideways so fucking fast. The sheriff went out and got the juror and brought the juror back in and was like, wait a second. did you misrepresent the way that this all went down differently? And the juror got in a whole bunch of trouble for the way that the juror represented it. I was like, oh my God. So many problems. The attorney got in trouble. The juror got kicked off. The juror got dragged back in by the sheriff and was like, So the reason you accepted the friend request is to get out of jury duty. What? So the juror also got in trouble. It's wild. But if the court's questioning you at sidebar about things, be truthful. Be truthful. That's all. That's all. Just be truthful. So there were some wild instances. California also had to add a civility requirement. The judges seem mad that the lawyers have taken the level of hyperbole up a lot of notches, and lawyers are starting to actually get in trouble, not just with the bar, but with the courts for breaching their civility. And it seems that judges are starting to crack down on that. And it's not just this level of hyperbole is unhelpful. Some of the email threads that were read because they've ended up in ethics opinions were so vitriolic, just so vitriolic. And I was like, oh shit. These lawyers are just calling each other every name in the book, are trolling each other, are like, maybe you should go ask your kids who they like, you or their real father, who's assuredly the trash man who drives by your trailer. Like that kind of level of personal insults in emails. It was wild listening to some of these emails. It was not subtle shade. It was direct, stop being an asshole type of shade. A lot of the things that came before the different ethics boards had to do with lawyers calling each other assholes. And I was like, okay, but lawyers are assholes. And one of the attorneys was like, yes, I called this attorney an asshole because they were being an asshole. I was provoked. And the ethics board is like, two wrongs don't make a right. That lawyer was being an asshole and is having discipline for being an asshole. You're being disciplined for calling them an asshole. I was like, oh my God. Oh my God. Okay. So the new civility requirements for the California Bar continuing legal education was hilarious to go through because the case examples were wild. And I think it was so funny when some of them were like, but I was provoked. Yes, you probably were. Have you met this profession? Oh boy. So it's going to be very interesting. Seeing like we had a few requirements. The requirements keep extending. Technology and civility was new. So, you shouldn't need a MCLE to be like, don't name call people and treat each other with decency and dignity and don't be a dick. And I don't know, just do your job. But no, we need MCLEs. Oh, and don't go messing around with technology you don't understand because you're going to get caught in 4K. I think that one's probably helpful for a lot of lawyers to remind them not to get caught in 4K and to remind them what the boundaries are of the research they're allowed to do on jurors, the research they're allowed to do on opposing parties in civil matters. I think it's incredibly helpful. And it's something that, since I've done jury selection, has changed. And so I actually found it to be very helpful to learn about the types of jury research these firms are doing now, because it is different than it was, obviously. So that was fascinating. That was fascinating to hear. But yeah, they, especially when it goes to civil, these firms will dig into everything they can find publicly. Damn it, this is the day to have the incognito spot. Get that information off the internet, and there's only so much they can find because they can only go to public sources. Just food for thought. Public sources. That's all. That's all. And if you have a common name and they can't associate the account by face or location, they can't be sure it's you. Just saying. Just saying. All right. Y'all really want to go through this third party culprit defense. So let's go through that. Hopefully we've made clear the difference between the Bowden defense and the third party culprit defense. I saw a lot of you in the chat saying that you thought I would lose my mind more over the denial of the expert. If it's true, and I don't know why it wouldn't be, that this is not regularly done in the jurisdiction, again, it's odd to me, it's surprising to me, but I can't be upset at the judge for denying something that would go against the grain of practice in their jurisdiction. It's the expected result is that judges will go with what is traditionally done in their jurisdiction, even if it's not what I would prefer to see. So there's only so much in this case I can lose my mind about. She didn't forestall them from making the argument, and she's not going to cut them off at cross-examination based on that ruling. So with that, I will reserve my rage for other things, because I'm sure that there will be other things to be rageful about in this case. It's just such an unusual case. Like, if it can go wrong, it will. This, I think, is also from yesterday, from the 31st. So let's dive in. Memorandum of Decision and Order on Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. Remember, at the first trial, I don't know if the court will talk about this is a first look together. Remember, at the first trial, the court said the third-party culprit defense could be brought if it was established by evidence, which is the law of the land. You have to establish in court by evidence, not argument, that there is a third-party culprit defense before you can argue it to the jury and before you can ask for the jury instruction. The defense did not ask for a third-party culprit jury instruction in the first case. They argued everything that was going on, but they didn't argue this person did it. They argued these people know more than they're saying, which is not specifically a third-party culprit defense. So the defense used third-party culprit more for impeachment than they used a third-party culprit defense. They never asked for the jury instruction. So let's continue. The Commonwealth moved to preclude the defendant from raising a third-party culprit defense. The defendant has alleged three potential third-party culprits: Brian Albert, Brian Higgins, and Colin Albert. For the reasons that follow, the Commonwealth's motion is allowed in part and denied in part. The opportunity to present third-party culprit evidence is guaranteed by the Due Process Clause of the 14th Amendment, puts it to the states, because it is rooted in the right for criminal defendants a meaningful opportunity to present a complete defense. You're allowed to say some other dude did it. The defendant may introduce evidence that tends to show that another person committed the crime, or, the or is a big part, or had the motive, intent, and opportunity to commit it. We talked about this during the motions in limine because you heard quite a lot of argument about both the Bowden defense and the third-party culprit defense. The evidence here and the argument here centered on motive, intent, and opportunity, not evidence that tends to show that another person committed the crime. The court goes on to cite case law that says the defendant's latitude to introduce such evidence is not boundless. The defendant's ability to mount a third-party culprit defense is not without limits, and that's coming from a 2023 case, Commonwealth versus Acevedo. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that it has substantial probative value and will not tend to prejudice or confuse the jury. That was the threshold that the court set up last time. The court set the threshold saying, once you get to this level of evidence, then we can get into the argument. Colin Albert. The court goes on to say, as to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, and opportunity to commit the crime. The court goes on to say the evidence of opportunity is wholly inadequate. That's a strong statement about the evidence. So it's a strong statement of the evidence. There was no evidence that Colin Albert was at 34 Fairview when the defendant and Mr. O'Keefe arrived at the home. I don't remember the evidence well enough on the timing, but I think the timing from trial was that he had left before Karen Reed and O'Keefe pulled up outside. That is to the best of my memory, but that's the court's determination of the evidence. So, and the court's allowed to determine that information because the court presided over the first trial, and the court in this hearing is the finder of fact. And the court's allowed to be the finder of fact in this hearing, whether you agree with the facts as she finds them or not. That is the role. That's the role in this motion. The court says the evidence of opportunity is wholly inadequate. There is no evidence that Colin Albert was at 34 Fairview when the defendant and Mr. O'Keefe arrived at the home, because I think they got there after the fact. They go on to cite, the court goes on to cite Commonwealth versus Fitzpatrick, third-party culprit evidence properly excluded where there was no evidence the third party had means or opportunity to commit the crime, and the evidence of motive was speculative and too remote, which I imagine, because the court is quoting that, we are going to see more conversation about it being speculative or remote, but we'll see. Evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. As to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans on O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial, footnote 1. To the extent that at the upcoming trial, the defendant would offer hearsay testimony to support the claim that Colin Albert had a feud with O'Keefe to be admissible, such evidence must be otherwise relevant, not tend to prejudice or confuse the jury, and there must be other substantial connecting links to the crime. And then that's citing case law. The proposed evidence does not provide a substantial connecting link between Colin Albert and O'Keefe's death. So the reason the court, and I see a lot of you saying, but this is a new trial. It is a new trial. However, the new trial, let me explain it this way. When the defense argued this at their motion hearing, they called back to the same things we saw at the first trial. And the court is saying, in your argument to the court, you argued the same facts that we saw at the first trial. And this is how they played out at the first trial. And because this is how they played out at the first trial, I find that it's not enough. They go on to say, the court goes on to say, even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate third-party culpability. The law's pretty clear on that across the board. Not liking someone or having a fight with someone is not going to be sufficient. The court cites a 2011 case saying fact of tensions between the neighbor and the victim was not indicative of the neighbor's motive to kill, and that the defendant offered and produced no evidence suggesting that the neighbor had opportunity to kill beyond that possessed by any neighbor. So opportunity is going to be different than motive. The court goes on to say, moreover, the theory that Colin Albert is the third-party culprit because he had scraped knuckles at some point after O'Keefe's death, had been seen in a video drunkenly taunting others with no connection to O'Keefe. Well, I mean, that's impeachment, and apparently was not named in police reports is speculative at best. I thought the court was going to go there when the court cited case law talking about speculation. Third-party culprit theory that victim was shot by unnamed rival drug dealer was based on quote-unquote rank speculation and properly excluded. You can't just say it could be, and it could be, and it could be. Let's see. Commonwealth versus Andrade. This is a 2021 case that the court is quoting, saying evidence that rival gang members lived near the shooting and were involved in feud with victims, not sufficient to support third-party culprit defense, where there was no evidence that they had been nearby at the time of the shooting. And the theory was, quote, speculative at best. Allowing such, quote unquote, feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth and would only serve to confuse the jury. And that's quoting Sylvia Santiago, also a Massachusetts case. So accordingly, evidence that Colin Albert is a third-party culprit is excluded from trial. The Commonwealth's motion in limine is allowed as to Colin Albert. So while they didn't argue all that much because they didn't get a jury instruction on it, that Colin Albert was a third-party culprit, I know a lot of you hate this result. Legally, I'm not mad about it. I think a lot of this will go to whether witnesses are being truthful or not. And a lot of it's going to go to impeachment of witnesses, not to third-party culprit. And I think putting in information about whether witnesses are being truthful or not is a different question than arguing this person had opportunity to do it. The court does not think Colin Albert was at the house at the same time John O'Keefe was at the house. So let's continue on, and then I'll give you my thoughts on the motion in total. But as to Colin Albert, am I outraged at this point? I understand where the court's coming from. The opportunity bit being the biggest bit. This Colin Albert's impeachment when he testifies will be different than third-party culprit. So again, we'll see some of the same evidence with impeachment, but there's not going to be a whole side quest showing that Colin Albert is the person who killed John O'Keefe. Now, if evidence comes in the case differently, just keep in mind, if evidence comes in differently, this is the type of ruling the defense can ask the court to revisit. Emily Ippolito in the chat said, so they can still impeach Colin on Colin being there, even if they can't explicitly say he's possibly the one who did it. Yeah, they can. They can still impeach Colin's testimony. Absolutely. And the defense can try to bring in evidence that shows if they believe that Colin was there at the time, the defense can try to establish that evidence and ask the court to reconsider this down the road. I don't know if it's helpful. Again, I think the Bowden defense is the stronger defense. So, Morgana said, how come deciding whether Colin Albert was there when the victim was, wouldn't that be a decision of fact for the jury? Not for this motion. So for this motion, the court is allowed to be the finder of fact to determine that the defense has not met their threshold. The defense has to make a showing that they're going to be able to establish evidence beyond speculation before you can point the finger at somebody. The Bowden defense is different. The Bowden defense is law enforcement should have investigated these individuals. And I can see this coming in with them saying everybody lied about Colin Albert being at the house. The law enforcement should have looked into Colin Albert more. Colin Albert had scraped up knuckles. Law enforcement should have followed up with Colin Albert more. Everyone seems to forget what Colin Albert's doing that night. Colin Albert should have been investigated more by law enforcement. Colin Albert said he's never been in a fight, but here he is in this video on social that's clearly accessible to law enforcement saying he's going to beat somebody's ass. They should have followed up on it. And so instead of saying Colin Albert killed John O'Keefe, the defense can argue these things should have been investigated. Law enforcement should have followed these leads. Those are different defenses. So hopefully that distinction makes sense, that they can take some of that impeachment evidence with Colin Albert and point it towards, shouldn't law enforcement have followed up and then argue? And they didn't because, the homeowner's a Boston cop too. It goes, I think, to the investigation. And I think that's fair. So Cheryl says there's nothing to follow up for calling him because it was proved he wasn't there. And that's what the court says. I think there's disagreement, but that's what the court says. And I think it allows, I think if the defense sticks down that avenue of the Bowden defense, they can make that argument and then the jury gets to decide. So we'll see. But let's continue. So that's what the court ruled as to Colin Albert. I get it, because with Colin, everyone said he wasn't in the house consistently. The weird thing is that nobody mentioned he was there. However, a lot of the witnesses said we didn't mention Colin Albert was there because we saw the car pull up and he wasn't there then. And if the jury believes that, then it's established that Colin Albert wasn't there then. If the jury doesn't believe that, again, the defense can bring this. So we will see. All right. But again, it can't be speculation. It has to be more than speculation. And I think a lot of the stuff with Colin Albert is, hey, don't all these things added together look bad? And that's not going to get you past that first hurdle. All right. Again, I think it goes to Bowden. Truly. And I think it's cleaner if it goes to Bowden. I also don't think it helps the defense to be like, on a third-party defense, it's really hard to say these three people did it. It's much cleaner to say this one person did it and this is why. Here's my opinion. When the defense argues it could be this person, or this person, it invites the jury to try to figure out which of those three, and it pulls a burden onto the defense that they don't have or need. When you do, police should have investigated this, and this, and didn't because of bias, because they were cops, because they're incompetent, whatever they're going to argue. Then the jury turns around and looks at what the police did, not trying to evaluate, well, if those three people didn't do it, then it must have been the defendant in the chair. So unless I don't love third-party culprit, unless it's a really strong third-party culprit. And when third-party culprit is could be A, could be B, could be C, that's not a clear and great defense. So that's where I'm at. Let's see. Jane brought up the screenshots. Jane said there was no proof Colin wasn't there with John O'Keefe, but there's no proof that he was there with John O'Keefe. All the witness testimony said he wasn't there, and if believed, that's sufficient. The prints were faked screenshots. I think the screenshots look weird AF, but it was not proven that they were fake. So we've got to go with what can be proved to the jury. And those weren't proven to the jury. So I think the screenshots looked weird too. And I think there was a lot of questioning of those witnesses that showed that they had reason to protect him. But again, if the jury believes the people in the house, everyone in the house said that he was already gone, to the best of my memory. Some of you are saying, no, somebody in the house said he was there. I don't remember that. But yeah, the texts were 100% weird. But again, it's my opinion that it is stronger to say law enforcement should have dug into this more, because doesn't this all look weird? Not this all looks weird, therefore he did it. This all looks weird, so they should have investigated it, and they didn't because his dad's a cop. I think that's the stronger argument. I know a lot of you disagree with me, and that's okay. I think that's the stronger argument. I really do. We'll see. Brian Albert, Brian Higgins. As to the Bryans, the defendant's proffer is barely sufficient. Well, we know what the court thinks of this, don't we? Again, hey, aren't they acting weird is not sufficient to say they committed a murder. It's not going to get you there. Let's go through what the court finds. The court doesn't think much of the defendant's proffer. And the court was letting them know. This is squeaking by. I wish that I don't know. I don't know if the defense is going to let the third party culprit go. I don't think they can. I think they're doing their job. But you know how I feel about the Bowden defense being stronger. As to Brian Albert and Brian Higgins, the defendant's proffer is barely sufficient, and the history of the first trial casts doubts on the seriousness of the claim. Them not asking for the instruction in the first trial, I think, is going to bite them here. I wonder if the court will bring it up with regard to these defendants. However, to protect the defendant's right to a fair trial and in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as it did the first trial. Defense counsel are ordered not to mention third-party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. I think that's fair. Footnote 2, the court notes that the defendant at the first trial under an identical order did not seek an instruction on third-party culprits. Right. The court's mad. The court's like, look, you brought all this, or you tried to bring all this in, and then you didn't ask for the instruction at the end. So do you just want to throw everything at the wall, or are you actually trying to build a defense? We'll see. The court clearly has some strong feelings about it, but said, though the court has strong feelings about it, the defendant has a right to establish this evidence. And if this evidence is established, then it will come in. But the court's just like, miss me? Let's see. Though the court may ultimately exclude the proposed third-party culprit evidence, or counsel may abandon the theory, that does not mean that the defendant cannot offer evidence to show the inadequacy in the police investigation. The court does the court think it's a stronger theory too? I think so. The court's made clear that this does not forestall the Bowden defense, which is what I just went on and on about. Emily, keep reading. This does not forestall them for saying these individuals should have been investigated. It doesn't stop them from saying that. It stops them from saying this other person killed John O'Keefe. Again, I think it's their stronger argument to say these three individuals should have been investigated. I don't think that's a bad argument, and nothing in this stops them from making it, which means they will be allowed to establish that same evidence to argue it for Bowden and not to argue it for third-party culprit, which they didn't do at the beginning. So the court, we know how the court feels. The court threw a bunch of shade in here that just wasn't necessary. But the court's giving, we're going to let you try, but I don't think you're going to get there. And the theory was abandoned last time. So, again, this is why you should have investigated can happen. And I think will happen. Will that mean they get a third-party culprit instruction? Maybe not. Will they ask for it? Maybe not. But the defense can ask throughout trial, hey, we've met our threshold. We want to argue this. I think that's fair. Order. It's hereby ordered that the defendant is precluded from raising third-party culprit defense alleging Colin Albert is culpable for John O'Keefe's death. The Commonwealth's motion is allowed as to Colin Albert. The defendant is not prohibited from raising third-party culprit. I hate not prohibited. Allowed? Can you just say allowed? Why the double negative? Counsel cannot mention potential third-party culprits in opening statements, but will be given the opportunity to develop the theory through relevant, competent evidence at trial. Again, beyond speculation, beyond, but isn't it weird though? There has to be more than that. And I think there's more than that when it comes to the behavior of Brian Albert and Brian Higgins. The court doesn't necessarily agree, but you've got opportunity because they were all at the house at the same time. Motive, we'll see. Intent, I think the defense started to get into, but that ruling is consistent with the first trial, except as to Colin Albert. Again, though, if the evidence changes, there's nothing to stop the defense from asking the court to reconsider this mid-trial. I don't know if they will, but I don't see this as a massive loss to the defense. I see this as the status quo from the first trial. And I don't disagree with the court that it has to go beyond speculation. You can't just say, well, these people were acting real fucking strange, so they probably killed someone. What you can say is these people were acting real fucking strange, so the police should have investigated why. What more do they know? And should have investigated that competently, and nothing here forestalls the defense for doing it. So we will see if the defense asks for this to be reconsidered as the evidence comes out. But a lot of these orders truly become subject to reconsideration if the evidence comes in differently. And we know that the evidence will come in differently. There's different experts. Everyone's had more time. There's new videos. But I did not find these defense arguments to be the most persuasive. Maybe that's why it being status quo doesn't really ruffle me too much. There's a long way you've got to go to establish these defenses. And the defense didn't seem to continue to, move the ball over the line the last trial. So again, I think the Bowden defense is the stronger argument. I think this all gets very confusing. And I don't think they established this well at the first trial. I think what they established well at the first trial was how bad the investigation was. But that also lines up with where I was at the end of the first trial. At the end of the first trial, I was left with this investigation was horrible and there are too many unanswered questions. And so that's how I see these arguments too, with there's too many unanswered questions. And if the defense can't answer those questions, then this defense can't be made in this way. I don't know. I don't think it really cuts off the defense when it comes to the third party culprit. I am more annoyed truly that the court has forestalled the expert for police procedures. I think it's needed, but again, the court is saying this never happens here. Well, we'll see. Because I've seen super chats from some of you saying there's plenty of attorneys in Massachusetts saying that's not true. And if that's not true, then that will, if she's convicted, be a very appealable issue. So, Nishay said, everything you said creates reasonable doubt. I don't disagree with you, Nishay. I don't. I think a lot of questions weren't answered in this case. And so when I'm looking at the case through that lens, I now have a lot more information in this case than I did going into the first trial. And so when I'm looking at how the court's evaluating things, we just have a lot more knowledge. And we can look at how the evidence came in the first trial and say, okay, well, if they meet that threshold, they'll be able to make that argument. I think it's a harder argument to make. And I think there are better arguments for the defense to make. And we'll see what they choose to do. I'm a big fan of keep it simple. And I think juries are too. I also think in this case, keep it simple matters because if the defense can keep it simple, the theory that's not as straight of a line becomes the Commonwealth theory. If the defense theory of the case is police picked one person who did this and looked at everything through that lens and considered no other possibilities, that's a pretty straight line for me. And I think Proctor's texts support that. The Commonwealth is like, well, it could be this. It could have happened this way. The coroner's not quite sure. And hypothermia's at the, at the undetermined mark. So with all of that, the Commonwealth's theory is less straight of a line. I was really hoping in the first trial, the Commonwealth would stand up at opening statements. Cancel whatever device is trying to do things. I was hoping in the first trial, the Commonwealth would stand up and say, this trial, the evidence will show that Karen Reed hit John O'Keefe with her car and left him to die in the snow because this witness, this witness, this witness, this witness, this witness, this witness, this forensic evidence, done. And that is not what happened. And the Commonwealth's opening was difficult to follow. So if the defense is more clear, it is going to help, I think, the jury be more clear, especially when it gets to count 2, which is very confusing. We've seen from the juror interviews that count 1 and count 3 aren't super persuasive. People don't think, or the first jury didn't think, by all accounts, that Karen Reed hit John O'Keefe with her car intentionally. So I see the fight as over count 2. And that I see as a really big fight. And I wonder if we'll see that narrowed down to a big fight over count 2, because I think the Commonwealth can show that Karen Reed was drinking, that Karen Reed was driving, and that Karen Reed dropped off John O'Keefe at 34 Fairview. I think those 3 things they can show. So we will see if they narrow in on count 2 or not. That's where I'm at. So Rex88 in the chat said, wait, I wanted to pull that up before the chat got jumping, and then we'll go to some of the hearing. I think the testing of driving 25 miles an hour backwards before they even had any data that happened shows the bias. I think the texts do too. They had a theory and try to fit anything to it. I don't disagree. I don't disagree. It's a difficult, it's a difficult case because the prosecution has not presented it well. And that's probably because the evidence isn't there for them. Stephanie in the chat said, I'm still 100% open to her being guilty if the prosecution can prove it. Yep. So far, all they've proven with trial 1 is that they're out to get Karen Reed. They didn't prove a lot. They proved she was drinking, I think. They proved she was driving. They proved that she dropped him off at 34 Fairview. They proved that she went back to his house at One Meadows. They proved that she went back there in the morning. They proved that it was snowing. They did not prove that she intentionally hit him with her car. They didn't. So we'll see. All right, let's go to the hearing this morning. It's going to take them 3 weeks ish to pick the jury. Shannon said in the chat, maybe they should do the Bowden defense and say it was biased because they didn't look into their buddies in blue and there was a conflict. I would like to see the defense focus on that a lot more. It also requires, there will always be jurors that are not going to believe a defense conspiracy that involves a ton of people. There are going to be jurors that are like, miss me with that. I don't think it's as hard to get jurors on board with, look at Trooper Proctor's texts, look at the fact that he's been fired, look at the fact that he doesn't want to look at any of the other cops involved. His viewpoint was always skewed. And he just, when all you have is a hammer, everything looks like a nail. He was going to make all of the evidence fit that point of view from the beginning and looked at nothing else. I think it's an easier argument to make. And I think that the defense has so much on their side to work with from the inverted video, from the lack of chain of custody, from the text messages, from the firing. I think the defense has so much to work with there that it puts the prosecution running around trying to what? Defend Proctor? If the defense narrows down on specifically this investigation was just shit, and there's a lot of sussy behavior that should have been investigated and it wasn't, and then you've got all these Proctor texts, what's the Commonwealth have to do? Defend Proctor? That's not a good position for them to be in. Can you imagine being the Commonwealth, having to stand there and go, oh no, this investigation wasn't totally biased by its lead investigator who was fired in part for his bias in this investigation? How? How do you get a jury on board with, yeah, this is totally trustworthy evidence? And that's your doubt. Done. That's your doubt. The end. The end. So we'll see what happens. Again, I have my thoughts on what I'd like to see, but the defense is the defense. They have lots of very smart attorneys working for them. They know the area better. They know the jury pool better than I do. They know it better now, having an alternate juror acting as one of their defense attorneys. So again, we will see. But I think the simpler it is, the better it is for the defense. Because then you've got to make the Commonwealth make it complicated. When you make the Commonwealth complicated, it leaves a lot of room for doubt. All right, I said the same thing 7 times. Let's look quickly at the hearing from this morning. We're gonna zoom that a little bit. Let me see if we grabbed it. There are some other orders and hearings that we will take a look at another day. Or I'll summarize them in quick bits. Well, in the Emily Show podcast, it's not even, it's the quicker than a stream bits. So with the quicker than the stream bits, we'll get there. We're going to take a look real quick at the jury questionnaire hearing. Thank you, Law Nerds, for mentioning it. Thank you, Miguelina. I thought there might be a hearing this morning, and then I hadn't seen it populate, and I was like, it's fine. We got other stuff to cover. So let's take a look back to live court from earlier this morning. This is going to be regarding jury questionnaires and procedure. I will probably put this at 1.25 quickly, and then zoom through what they're going to be asking the jurors. I'm always curious if they're going to, how much they're going to ask about social media, what their process is going to be, and then it gives us an idea of how long this might take. Jury selection is going to take time. We're not going to be seeing opening statements, I don't think, till the end of the month. I said that sentence really awkwardly, but yeah, the end of the month is when I think we'll see opening statements. So let us go to court. Hear ye, hear ye. Let's call court to order. Suzanne Jane, this is a very fair comment in the chat that said, wait, it was snowing that night. Did I miss it when it was briefly mentioned? Yeah, you must have. You must have. I know where everybody was sitting at a basketball game. I don't know how John O'Keefe was hit by a car. That's what I still don't know. Carly said, why not sequester the jury? Practicality. And I don't think it'll help. For all of you asking, is this a different courtroom? This is this judge's normal courtroom. In the first trial, the defense made a motion to not have the trial in this courtroom because of the weirdness of the jury box. Like the jury box kind of juts, the witness box kind of juts out to where the jury box is. And there will be some jurors sitting behind a witness. And the defense wants the jurors to look at the way the witnesses are testifying. Those witnesses, some of them, their faces were facing. Like, how do you evaluate what somebody's telling you if you cannot see their face? Also, it's real hard to pay attention if you can only hear them and can't see their facial expressions. So they moved to the other courtroom because the defense asked. And so they are going to move back to the smaller courtroom for trial, but they're going to use this one, it looks like, for jury selection, which makes sense. So this is a larger courtroom, and it'll make it easier to bring in. Some of you are saying they moved the witness box. I mean, if they move the witness box and they stay here, that'll be great. It's a bigger courtroom. So that would be fantastic. But that witness box was put in just a really weird place. I can't believe it hadn't come up before. That people were like, but if you're staring at the back of their head, how can you see them? I don't get it. So, Jebby in the chat said opening statements for Karen Reed will probably be the same day as Corey Richards. I know. I can't talk about it. I'm just going to wait for it all to work out. But Corey Richards isn't going to be streamed. So we're going to let it all play out the way it plays out. Let's go to the hearing.
Issue of the defendant's guilt to a reasonable and moral certainty, a certainty that...
Let me back this up real quick. This is the judge going through the jury instructions. Hold on. I am way too midway through. Sorry. I thought we were queued up to right at the beginning. I am incorrect. All right. Let's cue us back up. The white balance in this courtroom has been deeply impacted by the natural wood. No, Corey Richards isn't streaming. The court isn't even allowing it on a delay. It's going to be at least a day delay. There will be video, but it will not be streaming. So the wood has definitely changed the white the white balance in this courtroom. Oh, the old dusty law books. They make me itch. The judge gets lost on this bench. Just lost. This is not loud enough. Hold on. This is not loud enough for my beloved hearies. I love them so much. I'm never, ever going to be tired of the hearies. It's not going to happen. It is a delightful local quirk. So I had to back up so we could do the hearies louder. It was just not loud. It was just not loud
All persons have any business before the Honorable Beverly Kearney, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. Jurors remain standing. Everyone else may be seated.
I'm sorry, jurors, could I have you all raise your right hands, please?
Jurors now stand, which means they're in the large veneer. I don't even care if veneer is the proper way to say it. I cannot, which means the jurors are in the back of the courtroom and they're going to be read all these intro questions. They will not be shown on camera.
Do each of you solemnly swear to make true answers to such questions as should be put forth to you by the court?
And they're going to get a
Thank you.
questionnaire.
You can have a seat now, I promise. May I call the case, Your Honor?
Yes.
Your Honor, this is 22-117, the Commonwealth versus Karen Reed.
Counsel.
Do you want counsel? Or do you want me to say?
Counsel.
Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Do you think Adam Lally's sitting there going, it's April Fool's Day and we are starting trial on this case again? No one seems less like they want to be there than Lally.
Good morning, Your Honor. Alan Jackson on behalf of Karen Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Miss Reed.
Victoria George on behalf of Ms. Reed.
Good morning, Ms. George.
court.
Good morning, Ms. Reed.
I'm surprised that new attorney Victoria George is in court, but is in court sitting behind the defense table. And there you go. No, for jury selection, I'm not surprised. Because that's exactly, I think, why she's there is to look at jury selection specifically.
Okay,
Karen Reed, can you please stand?
But that's just speculation.
Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you object to any of them, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason. Thank you.
Okay. Good morning, jurors. My name is Beverly Kearney. I'm a judge.
Holly asked in the chat, did Emily say jury selection will take 3 weeks, or was it a comment? I said I think jury selection will take 3 weeks. It took 2 weeks last time, and there's been a lot more. There's been a lot more here. I think it might well take 3 weeks. And you guys are saying I'm a little unbalanced to court. I'll try to gain court down a little so we're more equal.
Judge of this court, and I want to welcome you here today and give you some idea on what you will be asked to do. So, jury service, as you know, is one of the most important duties we have as citizens. We appreciate that you're here, ready, willing,
I appreciate
and able
that
to
too.
serve
We're going
if
to
you're called upon
1.25
to do
you.
so, and our system of justice simply does not work without you. So
We are
thank you.
sped up.
This is the case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. So Ms. Reed is charged with second-degree murder. She is also charged with manslaughter.
For those of you asking, the court is not reading the probable cause affidavit. She is reading the statement of the case, which is agreed upon before the parties. The jury gets an overview of the case. So if jurors hadn't heard about the case, they know what the case is about, especially when you're dealing with alcohol-related driving cases. You will have some jurors off the bat whose lives have been impacted by DUI who are like, I cannot be fair and impartial on this case. I have very strong feelings about DUI. I've lost a family member, loved one, whatever it is, with DUI, and it will knock out some jurors who may not have heard about the case. So you need a statement of the case so jurors can know if this is the type of case they can't or won't listen to. Just like a juror who might have never had any impact with DUI, but might have been a victim of a home invasion robbery. They're like, I can sit on a DUI case, but if the case was a home invasion, they're like, absolutely no way. Absolutely no way I can't sit here for this case. So the jurors need to know enough about the case to know if they can sit through that case. And then they're going to go through the charges.
While operating under the influence and with leaving the scene after causing personal injury or death. I will describe these indictments in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that the murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in greater detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be
Quoting John Adams is the most Massachusetts shit ever. I am not mad about it at all. I am kind of tickled that they are directly quoting John Adams. Look, man, nowhere else have I ever heard jury trials start with quoting of founding fathers, but it is Massachusetts. So away we go. Look, in this case, they should also be quoting Sam Adams. Emily, too much. It's too much. It's not.
Your deliberations.
I'm tickled.
Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while the public opinion about a given subject may ebb and flow.
He's I said not right. I meant he's not wrong, but it is a great quote of the fact that the law must be deaf to the clamoring of the public, but it's not. Emily, you're going to start sounding like a really, really nerdy law student in 3, 2, 1, but the reason that we have a jury system is so the voice of the public is part of the process. The jury decides. And though it's not the quote clamoring of the public, the jury decides. And that's a huge part of our system is we do not leave it to lawyers and judges. Our system was set up specifically so that members of the public were the critical part of the system. So it's a bit of both. You know, the law is reason free from passion. Just bring it all back to Socrates.
The law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt.
I think it's fair, and the parties would have agreed about what the statement was about the publicity. I think it's fair to address the publicity head on because they're going to see it. They're going to see billboards. They're going to see people around the courthouse. They're not going to be immune to it. And I think it's a good way to address it head on that there are people advocating for both sides.
People outside of this building have rights, and we know that they have voices. But this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask you questions, all as a group, and then I'm going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process.
It's going to take a while.
As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you are not selected for jury service on this case, you should not take it personally. Don't think that somehow you're not a fair person, because it's not a reflection on you at all. You will be directed back to the jury room and perhaps be picked for another case. In a few minutes, I'll pose a number of questions to you as a group. You have just taken an oath that requires you to truthfully answer these questions and all questions posed to you. If your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer can read the number from the card. You don't have to get your cards out yet. I'll tell you when it's time to get your cards out. Now, the fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that counsel and I must discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer the question at sidebar. I may have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror in this case. And the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer to any question. We're simply looking for your honest and best answers to the questions. Now I'm going to have the lawyers introduce themselves. We'll start with the Commonwealth, and when the defense introduces themselves, please introduce your client. Mr. Brennan, please.
Thank you.
Case Kills asked to Case Silks asked a great question in the chat. What are they writing down, highlighting this early and in such a rush? They are prepping to start keeping track, and everybody has their own way to do it. You know how, I don't know, I watch a lot of TV and a lot of movies, and I don't know a better analogy, but you know how all ballerinas, especially every time they show ballerinas in anything, they all have their different ways of like beating the holy living shit out of their toe shoes. All of them have a whole different process for whether they're grading it or stitching it or whatever. They all have a separate process. Lawyers are the same way with jury selection. They're all going to have a different way to keep things in order, to keep jurors in order, to make notes and impression in real time. And they probably have a list of 100+ names in front of them, and they have to organize that list really quickly so they can start prepping for how they do it, whether it's with little Post-it notes, whether it's with a list. So they're trying to keep things in order to get started. And yes, it's quickly. Point shoes, not toe shoes. See, sure, I told you I'm terrible. The dancy shoes. But everybody's got their own way of making sure their shoes are how they need them for like game day. And we've now mixed analogies, but it's the same with lawyers. Everyone's brain works differently on keeping track of jurors, and you need to keep track of your impressions. There are things that can go on during jury selection where you are challenged for dismissing a certain lawyer, where a lawyer is challenged for dismissing a certain juror. You need to have your notes and you need to keep track. And when it's 50 people, it's one thing. When it's 150, it's another. So it depends on how long their list is, and then how long their list is and who actually shows up in court today. So it is a whole thing. Nishay said everyone looks so red. The white balance in the courtroom is off. I don't know how hot it is in Massachusetts, but it's off. And I'm the same way, Elizabeth. I'm fascinated by all the videos of how people take care of their shoes, but it's very specific to the individual. So toe shoes, point shoes. I've conflated skating and ballet, right? Toe pick, toe point, point shoe.
Ladies and gentlemen, my name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me and two other...
Did the court sigh the second he started talking? Hold on. We backed up.
Please introduce your client. Mr. Brennan,
Your Honor.
please.
Thank you. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me and two other attorneys I'd like to introduce you to. All the way to my right is Attorney Laura McLaughlin. And next to me is Attorney Adam Mallory.
Thank you. Defense counsel, please.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the privilege of representing Ms. Karen Reed, who is to my right.
Alan Jackson has taken my 1.25 speed and put it at like 2.25 speed just because of how fast he normally talks.
Good morning, members of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen of the jury. My name is Robert Alessi, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have an office in Boston. I also have an office in Dedham. It's my privilege to represent.
Ladies and gentlemen, I'm local.
Good morning, members of the jury. My name is Victoria George, and I have the pleasure of representing Ms. Reed.
I work with...
Thank you for being here.
All right. Thank you very much. Folks, I'm going to read a very lengthy witness list to you.
The lengthy witness list we're going to skip. I wonder, for some jurors, when it becomes too much. I just wonder if that many attorneys might have an impression on some of the jurors. I'm just curious. Shelley said, oh my God, great analogy. I'm a competitive weightlifter. I have a very specific way of setting up my personal equipment at competitions. It makes my brain happy. Exactly. And I've done archery. It's the same thing, but you also you have different equipment that you like, and you have things you want for competition versus things you want for practice. But the breaking in the point shoes was the best analogy because it is so destructive and so different, and everybody's got their own way of doing it, and it's, well, rapid fire. We're going to skip this witness list real quick because we've seen it, and it is, in fact, lengthy, and what I don't need is Bev reading a list of names.
Mass State Police, Lieutenant Paul Gallagher from the York, Michael Bradford from the Needham, Timothy Nuttall. When we start the trial, we will go full days so that we can expedite the trial. The dates that I'm giving you, the 6 to 8 weeks, is the far end of what we expect this to be, just for planning purposes. So the days will begin at 9 o'clock. We'll take a recess at about 11 for 15 or 20 minutes. We'll go until 1. Lunch will be brought into you. We'll start up sometime around 2 and go till 4 o'clock or 4:30 every day. And there'll be days off here and there throughout the schedule, and perhaps half days throughout the schedule. So that's the schedule that we intend to keep. Now, it might help you if I give you a preview right now about some basic law that applies to criminal cases like this.
Weeks.
It's my job to teach.
She said 6 to 8 weeks on the outside end. We'll see.
Teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the legal principles that govern the trial. First, and most basically, the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation.
These are read again before opening statements.
An indictment is merely a formal manner of accusing a person of a crime in order to bring her to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt.
Like that
if the Commonwealth does not do that, then the presumption.
This judge takes lunch on time and stops on time. I'm not mad about it. We're going to give credit where credit is due. Stopping on time, she absolutely stops on time. We're on the dot.
Of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the Commonwealth, you accuse me, now you prove it, and prove it beyond a reasonable doubt. I do not have to say a word. A defendant's decision, whether...
I like the way the judge elucidates that for the jury. This judge's demeanor with the jury is so much different than her demeanor with the attorneys. I imagine that jurors probably like this judge quite a lot, but I like the way she broke down that explanation, which is, you break it, you bought it. Like, you charged me, you prove it. What? I like the way she broke it down.
Or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a
Planner Princess said, I'm confused. Has the jury already been picked? No. This is the very, very first veneer. This is the beginning of the beginning of the beginning. So the judge is reading in all the initial stuff before she takes the entire group they have and start doing the questionnaires. We are way at the beginning.
Reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before the jury in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt.
She's going to read this to every group that comes in.
A juror's job is to find the facts and determine.
So they bring in large groups. They go through that group. If they need to bring in a fresh group, the fresh group will hear this. But they're bringing in a large group. They're going to do questionnaires. They will probably let some of the group go, and then they will start questioning them one by one. So This process with this group will probably take a couple of days. And then if a new veneer comes in, then the new veneer will get read this. They won't read it every single day, but each new group will get asked this every time there's a new group. But this veneer, and I've seen a lot of you in the chat saying it's about 92, which I'm sure has been reported elsewhere. That will take a couple of days because they'll do the questionnaires. They'll go through and kick people on the questionnaires. Then they'll do individual voir dire. They'll do the group questioning. It's going to be a busy couple of days, but no, she won't read this every day.
Determining the facts, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and circumstantial evidence. I'll define those terms in greater detail later, but direct evidence essentially is evidence of what a witness claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you were provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Jurors are entitled to consider both kinds of evidence. There is no difference at all in the probative value between direct and circumstantial evidence. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt.
Nope, these have to be read live.
Now, I've used the word inference. An inference is a logical deduction or conclusion that you may, but are not required, to draw from evidence that you have accepted as believable. Inferences.
First trial took a little bit more than 2 weeks to pick a jury.
Apply your experience in life to it and then draw a conclusion.
She's talking about types of evidence.
Drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one which is not too remote in the ordinary course of events.
So they're all prepping.
You may
their
not guess. You may not speculate or engage in surmise. When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, obviously, as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of on unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you individually and as a group do your best to resolve this case based upon the evidence and law without sympathy, bias, or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it. So for jury selection, it's important to know if any of you might have doubts whether you can accept and follow these legal rules. So I'm going to ask you questions in a few minutes. So if your answer is yes to any of my questions, please raise your hand. Before we begin, though, I understand that sometimes jurors do not fill out the juror questionnaires completely, that sometimes we are in a rush to send them in, or sometimes we don't think that our situation applies to the question that is asked.
Please
if the lawyers
fill
and
them
I
out.
notice that the questionnaire appears to be incomplete, we may ask you to answer the question for us. Also, if you know now that you failed to include information on the questionnaire, for example, a work history, prior involvement with the court, whether as a party in a case, a witness or a juror, please let us know. So while you're taking out your cards, I will see counsel and Chief Rosen, juror number 79 too, and counsel at sidebar, please.
All right, they're already pulling a juror up at sidebar, which means I imagine the camera's going to go to the window or to the walls. No, it's going to go to the highlighters. I mean, we know Alessi's going to be color coded. We love the highlighters. We love the highlighters. Let's zoom past that. I wonder if they already have the questionnaires. They might not. Because I thought she said she was going to send them out to fill them in, but it looks like they already actually have them. So that would have also been what they're highlighting is the jury questionnaires. So, and they already have those.
Going to ask you and the
All right.
So now I have questions that I'm going to ask you, and the court officers will read your number. So if you have that card, and hold it high.
We got remarkables. We got remarkables on everybody up here. So no, it looks like the jury questionnaires are already in, and that's what they were going through so quickly.
Aye, please. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've read? Please raise your hand.
96, 96, 32, 32, 59, 59.
So they're doing the broader questions. And
46.
the attorneys have to write these down as well to keep track of who knows what, where,
All right,
and how.
Thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or with the Norfolk County District Attorney's Office?
And then they hold up their little jury number, call them out.
I see no affirmative responses. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome?
What, are you betting on it? I'm
I
teasing.
see no affirmative responses.
There's other reasons that could come up.
Has anyone seen, heard, or talked about this case? Please raise your hand.
Juror number 47, 47. Juror number 108, 108. Juror number 54, 54. Juror number 4. Juror number 7. Juror number 95, 95. Juror number 12, 1, 2. Juror number 35, 3, 5. Juror number 2. Juror number 107, 107.
It's a lot of jurors.
41, 41. Juror number 46, 46. Juror number 24, 2, 4. Juror number 97, 97.
It's a lot of jurors.
23, 23. Juror number 99, 99. Juror number 25, 25. Juror number 90, 90. Juror number 92, 92. Juror number 91, 91. Juror 106. Juror number 101. Juror number 68. Juror number 65. Juror number 105. Juror number 60. Juror number 115, 115. Juror number 76. Juror number 66. Juror number 85.
Juror number 57, 57.
They're not done calling them all out yet that have heard about this case.
96, Juror 109. Juror 113, 13. Juror 73, 73. Juror 31, 31.
As they continue to call out the numbers, remember, hearing about this case or talking about this case does not automatically exclude them from being on this jury. They're not going to just kick everybody who said they've heard or discussed this case.
Juror 59, 59. Juror 40, 40.
So,
Juror 94, 94. Juror 3. Juror 86, 86. And Juror 62.
put on the background music.
Juror 84, 84. Juror 112, 112. Juror 64, 64. Juror 82.
We're just, they're still calling numbers. All of the numbers. So many numbers. It does sound like bingo calling. They're still calling numbers. Still call the numbers.
Juror number 7-8. Juror number 1-8. Juror number 6-7. Juror number 3-7. Juror number 6-9. Juror number 6-3. And juror number 2-2.
Juror number 30-30. Juror number 45-45.
Okay, thank you. Have any of you folks expressed or formed any opinion with respect to this?
And I have this sped up. So have you heard about the case, talked about the case? Lots and lots. Have you formed an opinion on this case? These are the folks that'll get kicked.
Case. If so, please raise your hand.
Juror number 108, 108. Juror number 7. Juror number 95, 95. Juror number 107, 107. Juror number 2. Juror number 35, 35. Juror number 8. Juror number 97, 97.
Juror number 90, 90. Juror number 91. Juror 106. Juror 101. Juror 105. Juror 60. Juror 115, 115. Juror number 66. And juror number 85.
Juror 109.
For those of you who asked, what if they're not being honest? That's what the rest of voir dire is for.
Juror 9-4.
They take an oath. You have to hope that people are being
Juror 5-9.
honest.
Juror 5-3. Juror 84.
So these are the immediate yeet categories.
Juror 6-4. Juror 82. Juror 7-7. Juror 17, 1-7. Juror number 7-5. Juror number 4-3. Juror number 2-9. Juror number 2-8. Juror number 1-1-3. Juror number 3-6. Juror number 1-8. Juror number 3-7. And juror number 2-2.
All right, thank you. Are any of you folks aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? If you believe that you might have a bias, please raise your hand.
Juror number 25. Juror number 8. Juror 90. Juror 91. Juror 101. Juror 105. Juror 65. Juror number 60. Juror number 115, 115. Juror number 66. And juror number 85.
Juror number 1-7.
This is a lot of people who's like, I cannot, 100% cannot sit on this case.
Juror number 3.
Cannot.
All right, thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
Juror number 95, 95. Juror number 8.
Juror 101, 101. Juror number 65. Juror 105.
Juror number 13. Juror 31, 31. Juror 7-5. Juror 3-6. Juror 9-8.
And these are going to get to if you can't hear me, but also paying attention.
Would any of you folks have
Back
any
pain,
difficulty following the concepts that
etc.
I've described? First, that the burden of proof rests entirely with the Commonwealth. Second, that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She's presumed to be innocent unless and until the jury determines that the Commonwealth has proved its case beyond a reasonable doubt. Is there anyone who would have difficulty following those very important constitutional concepts?
Juror number 58, 58.
I like that Alessi is looking at the jurors and not just noting down the numbers.
Now, I can tell you folks that after every jury trial, I talk to jurors, and they often tell me not only that their jury experience was an interesting one, but a rewarding one. I do understand, though, that for a few of you, however, service in this jury may be a substantial hardship, and let me explain what I mean by that. It's something more than mere inconvenience, because every civic duty we have causes us to be inconvenienced. It's far more extraordinary. It's something that would justify your being excused and a fellow juror having to serve in your place. I do understand, though, that it may be a substantial...
Danielle in the chat asked, is it normal for this many people to have heard about a trial, formed an opinion with a high-profile retrial? Yes. With your everyday trials, not necessarily. But this is a very high profile, particularly locally, retrial. So yes, I'm not surprised by how many people have heard of the case. I'm not surprised that people have made up their mind about the case. I'm sure there are people that got pulled in there that watched the last trial or have watched the docuseries or what have you. But it doesn't surprise me for this case, given how locally impactful this case has been. It is difficult, I would imagine, to be in Massachusetts, particularly the nearer you get to Canton without having heard about the case, talked about the case, thought about the case, seen news about the case. It gets very difficult the more local you are.
Hardship. So if anyone has a substantial hardship, and what I typically mean by this is you have airline tickets or surgery scheduled during the course of this trial. But bearing in mind that this case may take 6
I have concert tickets. We have concert tickets. We have concert tickets.
to 8 weeks to try according to the schedule that I've described. And keep in mind that I'll only excuse those who have a substantial hardship. If you think you are in that group, please raise your hand.
Concert tickets don't count. She'd be like, we can break early that day.
97, you're number 47, 47. You're 108, 108.
But having plane tickets, cruises, surgeries, things that cannot be changed, matters.
Number 90. Juror number 91, 106, 101,
That's a lot of jurors who are like, I've got plans.
105,
It's going to be summer, though.
70,
Well, it's going to be May. It's going to be summer.
Juror 109, 13,
No, missing a concert wouldn't count. The court would break early for the day unless you had plane tickets. And if you had plane tickets, then it would count.
53, 110,
Concert tickets would be, we'll take a half day so you can get there.
4, 82, 17, 17. Juror number 43, juror number 42, juror number 69, and juror number 63. Juror number 62, 62.
Juror number 41, 41.
All right. So in a few minutes, I'm going to leave the bench to give you a chance to fill out the supplemental questionnaires that
gonna
we
take
have. I ask that you
a
not
while.
talk to anyone around you or share with any other prospective juror or anyone
The additional
any questions or
questionnaires,
comments
that
or
makes
concerns
sense.
that you may have about jury duty, either generally or in this particular case. If you should have any questions or concerns, you can raise that when you come back
Don't
to
talk
talk
about
to
the
me.
case.
So we appreciate your patience. We understand that this will take a while. But I will recess now for you to do
Yup.
that. All right. Thank you.
So they had the initial jury questionnaires. That clock is kind of fucking epic. I like it better than the OnlyFan. The clock's pretty lit. Can we back out on the clock a little? Because it has one of the like bongly things down at the bottom. I have no idea what it's called. It's got like a dongle down at the bottom. I dig the clock. It looks like it's made out of fucking marble. It's very cool. So the jury questionnaires, the initial questionnaires seems to be what the pendulum, thank you, dongle. Oh, well, I guess they don't come back onto the bench. That's all she wrote, folks. So it looks like the court does not come back onto the bench because that is the end. Let me see if there is another part. I don't see another part to it. So it looks like that's all we've got. This is going to take quite a while. If the court comes back onto the bench, we'll cover it the next time I'm streaming. They're going to continue to do this. We are not going to hear many of the substantive answers. You're going to get a show of hands. The one-on-one voir dire is going to be at sidebar. You're not going to hear anything about it. And once they get to doing the regular one-on-one voir dire, I don't think we're going to get back to seeing any of this be televised. But next week, we have Kohberger hearings that we need to cover. And we have a ton of Kohberger motions in limine that I'll be covering before those hearings. So almost all of next week will be Kohberger stuff. If Reed stuff pops up, we will do our best. You have to make sure you have the Lawnerd app to stay in the loop. We did an extra hearing today, and look at us, we're still under like 4 hours. Yay. But you have to make sure you have the Lawnerd app so when I go live, if I go live out of my normal times, that we are covered. Remember, I will not be live except for members only tomorrow. Members only, I do not know exactly what time. It depends on kiddo appointments. It's going to be afternoon Central Time. So it will be after 1 p.m. Central. It will not be before that. So don't worry. We will be live for members only tomorrow, but it will just be members Only tomorrow. So let's do a few of the questions, and then we are going to get going. But that's the beginning of the very long process that is voir dire. The picky, guessy, choosy, seat and yeet, call it what you will, but that's the beginning of a very long day. Miguelina, I think we did a summary of the motions. I don't know if we need to do a summary of that video, because I think we did a summary of the motions, I think. Christina said, does members include YouTube members? Yes, it does. But if we didn't summarize the motions, I can try. Let's try to summarize the motions. I think we did, but maybe not. We're not going to summarize the hearing, though. Oh, okay. Thank you, Miguelina. Miguelina's like, you did not summarize the hearings. We jumped directly, or into the orders. We jumped directly into the hearing. Fair enough. Let's try to summarize. Today, we took a look at the court's order regarding the defense of third-party culprit and regarding the defense's proposed expert regarding police procedure, which will also go to one of their defenses, what in Massachusetts they call a Bowden defense. The Bowden defense roughly encompasses law enforcement didn't investigate things they should have investigated, didn't follow proper procedures, and allows an instruction to be given regarding the police investigation. The court denied the motion for that expert and pointed out in her order that she had not seen another case in Massachusetts where that type of expert had been used, which is incredibly unusual to me because this is really frequent in other jurisdictions. It was strange to me at the hearing over this motion in limine when the court said, I've never had a case where anyone's done that. I've not seen that done, because it is such normal procedure elsewhere to bring in an expert in policing and say, this is normal policy and procedure. This is how police do a chain of custody, and then juxtapose it to what was done in a case. The court cited a lot of case law that said that this is done through cross-examination and is allowing the defense to do that through cross-examination, but not through their own expert, saying that that's not what's done in the jurisdiction. If that is an inaccurate statement of the position of the law by the court, then it'll come up if Karen Reed is convicted on appeal. But as we are getting into jury selection on April 1st, the court needed to get these rulings done and out, and we'll see. Who knows? Could the door still be opened and the defense still argue they should get that expert? They can try, but when it comes to bringing in an expert, it's going to be a bit harder, but the discovery's all been turned over. So we might see further argument on that depending on how the evidence comes in. And the court denied the defense third-party culprit motion with regard to Colin Albert, allowed it with regard to Brian Albert and Brian Higgins, much in the way she allowed it in the first trial, which is if the defense establishes the threshold evidence, then they can argue third-party culprit or ask for the third-party culprit, ask for the third-party culprit jury instruction. And the court noted in a footnote that the defense did not ask for that instruction in the first trial. The court had some pretty strong language for how the evidence came in her order. We are starting to see that, we've seen that in a couple of her orders, but it was very strong language for how she felt about the third-party culprit defense, pointing out repeatedly that it needs to be beyond mere or rank speculation, that there needs to be evidence established to provide it, and will not allow the defense to go down that road with regard to Colin Albert. The court also pointed out in that nothing in that order will forestall the Bowden defense, and part of the Bowden defense can be these individuals should have been questioned more. These individuals should have been looked at by police more. Their behavior was this, and the investigation was this. So it doesn't close a door on the Bowden defense. It requires the defense to meet the threshold to bring in that third-party culprit with regard to Brian Albert and Brian Higgins, the way that the court ruled during the first trial. We will see if the defense tries to open that door, or if they try to establish that evidence as impeachment and as evidence that these individuals should have been investigated more. That's different than saying one of these individuals did it. This is the person that did it. I think it's an easier argument for the defense to say, look at some of these individuals, look at their behavior, and they were never investigated. I think the Bowden defense is the stronger defense. The defense, though, gets to choose what they want. They can choose to bring a third-party culprit. I do not think it's their strongest argument, but they have to meet that threshold first before they get a jury instruction on it. We will see how that all plays out. Again, the court has ruled that it can't come up in opening statements because that threshold won't have been met yet because evidence hasn't come in. And we saw the defense staying away from that in opening statements last time, really going into the police investigation and opening, not into this third party is the one who did it. That is the differentiation between that Bowden defense about law enforcement and the third party culprit accusing someone else of committing the crime versus it just wasn't investigated and should have been. But that door seems to be closed with regard to Colin Albert. I don't know if we'll see the defense asking for that to be reconsidered as we get into trial, but they can ask for that to be reconsidered. And I expect we will see other rulings and motions continue to play out as we get into jury selection. The court has indicated to the jurors that this is about a 6 to 8 week trial on the outside end of it. And the court has said previously, and I don't disagree, that this jury selection might take 3 weeks. And the court was really looking at the end of April for opening statements in this case, but was giving time for the First Circuit to rule. Well, they've already ruled. They denied the habeas petition again, or technically they affirmed the denial of the habeas petition. So this case is full steam ahead. It's going to take time to pick a jury, and it's going to be day by day of individual voir dire, and quite a lot of people who've heard about the case, quite a lot of people that have already made up their mind about this case. After a second trial, it is hard to keep an open mind if you know about this case. It is going to be something that I will be working on. I'm sure it is something the law nerds will be working on, is new case, new information, and I will try to keep an open mind. But the questions I had from the first trial that are still not answered become a bit more ingrained in your brain when they are still lingering going into a second trial. I'm interested to see what witnesses get called and don't vis-a-vis the first trial. I'm interested to see if the opening statements change or the tenor of those change. And of course, we have a whole new prosecutor on this case. And by the looks of it, we're going to see that prosecutor do just about everything. And I'm interested to see what a Brennan opening statement looks like in this case. So when will we get to opening statements? Probably the end of April. All right, law nerds, let's get to questions because we need to do questions. Let's do that. It's time. It's time. We're going to do questions about this case and about the jury. Jamie asked early on in stream, what if an unbiased jury can't be secured in Massachusetts? Well, they have to find a jury, and they will continue impaneling people until they find a jury, but a jury has to be impaneled in Massachusetts. It is a state case. They have to find a jury in the state and in the jurisdiction. They can expand the net, but they haven't done so yet in this case. No, I think they embiggened beyond just their county, to the best of my memory, but they did not swoop it out too far because there's also rules about how far you can make somebody drive for jury duty. So I've never seen a case where they have not been able to find a number of jurors that they need. It's gonna take some time, but I think they will be able to do it. Agatha Rose said, Emily, genuinely, wholeheartedly, thank you for doing these streams. You are great for body doubling. They are great for body doubling. Yes, there are so many in our chat that are just working along with us. You are not alone. The chat gets so much done. You guys put in the chat what you got done today while you were listening to this stream. Y'all get so much done. You get work stuff done, school stuff done, crafty stuff done, house stuff done. Y'all get so much done. Y'all go to the dentist. You bring me to the doctor with you. It's great. All of you get so much done. So yes, I feel less alone on this neurospicy journey when I hear your voice. Honestly, thank you. Agatha, you are welcome. There will always be a stream to pop on in the background. Christy said, Emily, I just flew to Charlotte and thought of you. Did you intend to go to Charlotte? The way I double check now when I go to Charleston, the way I double check. Susan Jane, thank you for the gift of memberships. New members, remember, we have a members only tomorrow. You'll see it in your community tab. Jay McCarthy said, I love being a law nerd. I love this community. I love being a law nerd too. It is just the best. AV to the seventh power, good to see you in the chat, said, come to Boston. I have, it's been a minute since I've been to Boston. Dave is playing in Boston in May, and I think I'm still going to be covering this trial when Dave is in Boston. It's been a minute since I've been to Boston. I love Boston. So we will ship up to Boston again soon. The dash in between with Matt Bond said, Minions! Tonight we are going to steal the moon. Morning, spiffy legal mumbo jumbo talkie sister from another, Mr. from another me. Matt, it's good to see you in the chat. And yes, minions. Respectfully equals Brennan. Did I fucking stutter? That judge was like, come on now. Solo Cups says Bravo is in this photo and they don't like it. Look, the Bravo sassy edit comes in sometimes. Nap trap and trying not to rage. Sir, yeah, nap trapped is hard. I get cat trapped all the time. I love it. Love it. Christina, good to see you. Sorry, I don't know if I missed it, but will you be covering the jury stream today? We got through what was aired, so yes. Due to Lawnard request, we did get to there. Learning every day. When does the Reed trial start? Today, technically, is when it starts. The evidence should start at the end of the month. So we will get there. I saw a lot of you asking for the judge from the hearing earlier today. For this case, that's not going to happen at this point. Let's see. I'm going to get to some other questions. Where are we? Amy Z said the Canton Police Department was audited and the results came out today. I'll take a look. They specifically issue findings on the handling of this case. I'll go take a look at it. Can the defense use it? I'll go take a look at it. I'll go take a look at what it is and how it was done before I answer that. But the defense is probably going to try to use it because they're raising a Bowden defense about law enforcement handling of the case. So if there is something that deals specifically with law enforcement handling of the case, I imagine that they will argue for it. But before I can give you a more definitive analysis, I want to look at it. But I'll take a look at it before we stream again. So that. Let's see. Cat Call said, is there anything the defense can do regarding getting this expert in, or is this the absolute final word in driver's licenses? A, 10 out of 10 clueless reference. Love it the most. B, they can try to argue for the court to reconsider based on things that happen in trial because all the discovery's been turned over. So there's not a discovery issue. So yeah, they can try again. I don't know if it'll fly, but I imagine that they will. They will try again. So I don't think we're going to see the defense not ask for reconsideration down the road. I would probably, if I was the defense, I think I would wait to let the evidence come in because it's not an expert that they would mention in opening. They can argue in opening things like the evidence will show that a chain of custody was not completed. They can already argue those things based on the witnesses that are going to testify and then let the expert or argue to get the expert in later as the cherry on top. So it's going to depend on the way the evidence comes in. Let's see. KRP in the chat said, how will the Commonwealth be able to present Karen's statements in the documentaries without Karen testifying? Because they are statements of a third party opponent and they can roll the tape. So that is the concern of doing series like that. They can literally roll the tape. And that's going to be wild. Let's see. Stephen said, if judges are always following precedent, who's setting the precedent? The appellate and Supreme Courts. This case, why wouldn't you want to set a new precedent that would allow for the justice system to work better? I just have questions. Stephen, I completely understand your questions. And it is not the role of the trial court to set precedent. It is the role of the appellate and Supreme Court. It is the role of the trial judge to follow the law as it is. And we've seen that in the Corey Richins case where the court said, I am following the law as it is today, though I do look forward to when this law changes. The judge said, I'm open to the appellate court changing this law or to the legislature changing the law, but that's not the law of the land today. And I have to follow the law as it is today. And if the law changes down the road, then an appeal happens, then it gets sorted out by the appellate courts. So you've got to go through all those layers. It is slow. But also the law should be consistent, and having it move slow is part of how that consistency is maintained. You also don't want to go into one courtroom and have a totally different result than in another courtroom. And if you have trial judges not following the law of the land as it is, you can end up with equal defendants not being treated equally because judges are just doing whatever. So it is slow. But if that is the law of the land, the only way it's going to change is if it gets appealed, or if judges start saying, no, this makes sense for an expert. For me, an expert like this makes sense. I don't know why it would even need precedent. It's an expert. It's just an expert in a different subject area than you're used to. But the rules on an expert are clear, and the law says that a Bowdoin defense can have an expert. I don't know why this expert's ruffling everybody's feathers, but it's not, I don't know. It's hard for me to envision it because it's not weird to me. So it's hard for me to see where the court's like, oh, this is strange. Can these motions be appealed? Not until, these are not the types of things that are going to be appealed until or unless there is a final result in the case. So no, not now. Stina G said, so I got a grand jury summons. Note to self, check my shit, but really advice, kind of excited, kind of hesitant because of all we've seen recently. Grand jury's totally different, Stina. I think grand jury's incredibly cool, and you never know what kind of grand jury you're going to get onto. Some grand juries have evidence presented to them. Some grand juries get to do investigative work, and they get to be like, yo, you know what would be really helpful? Bank records, phone records. Like, you have subpoena power. You can go hunt down information, ask questions. It's a much more active part of the process than being on a trial jury. So I think being on a grand jury would be the coolest shit ever. That's personal opinion, but also the type of research that they do into jurors is different than at a grand jury. Those are an investigative body. So that, let's see. Lots of questions that I've already answered because you guys were all on the same wavelength today. So that's what I'm going through. Let me see. These are, Michelle said, isn't there overlap between Bowdoin and third-party defense? Sort of. I think jurors wouldn't care if the investigation was poor if they can't see anyone else who did it. There is overlap in that part of a Bowdoin defense can be these other options should have been investigated. And the investigation was just like, la, 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 whatever, which is different than saying this person did it. It's focused on what investigators should have done, not saying someone else is responsible. And I think it's because of the way the evidence came out in the first trial, the reason I think it is a stronger defense is because how does the Commonwealth counter the argument that there was bias in this investigation? I truly don't know how they counter that argument. So the focus on law enforcement refused to do a thorough investigation, I think raises doubt. So we'll see. Lauren M said, will this jury be told it's a retrial? No, but some of them surely will already know based on how many people have heard about this case. Let's see. Becca said, yes, there is another case, was in here last week, and they even had a jury instruction to not watch the Karen Reed trial, same investigators. In the same courtroom, I saw that there was a clip of a judge saying you can't talk about other cases in the building either. Jonathan said, Bowdoin defense should allow defense to question troopers also involved in the Birchmore case to show if bias, if police officer involved as possible suspect. The Birchmore officers won't come in unless they overlap in this case. But in this case, anyone that is between the two will be able to be questioned. How much they'll be able to be questioned about Birchmore, we'll see. There were a lot of motions about getting some of that investigation. Taylor said, as a ballet dancer on point, I feel so seen. I have the most respect. Like, I loved water polo, and sometimes it was painful and bloody, but it's nothing compared to point. Like, that shit's intense. I could also, I played water sports because I have no balance. Mad respect. Also, there's not as much modifying of bathing suits that needs to happen. It's mostly just trying to like get into it without ripping it. Emily Ippolito said, between the pirouettes and the point shoe analogy in this case, my former dancer heart is full. I mixed analogies at some point, but it seemed to make sense in my brain when I said it. Jill said, will Dunkin' Donuts be sponsoring this trial? Look, I want Dunkin' Donuts to sponsor me through this trial because I'm going to need the sugar and the caffeine. Also, the breakfast sandwiches are really good. Like, the longer I live in a non-Starbucks forward state, the more it's starting to turn me. Look, in college, when I went to UMass Amherst, I was like, how is there not like a bagel place? Like, everything is Dunkin's. Also, how is there not a Starbucks? Like, I am a basic Starbucks bitch. But you know what none of y'all said to me? I mean, we weren't all doing this when I was in college, and it probably didn't exist then. Dunkin' has snack and bacon. Dude, that shit is so good. Shit is so good. The breakfast sandwiches are so good. They are. Also, Starbucks prices keep going up, man. The quality hasn't gone up. And I like Starbucks, but Dunkin' is the breakfast sandwiches are yum. Just yum. So I'm becoming a bigger fan. And also, I like making coffee at home. So now it's just like, I want snack and bacon and breakfast sandwiches and donuts. And it feels less weird to me to go to Dunkin' to just get food. I just need them to have more cake donuts. Those pumpkin cake donuts are, Emily, are you hungry now? Yes. Those pumpkin cake donuts over like Halloween are so freaking good. They need to keep those through like January. But I am a huge cake donut fan. Again, grew up in Southern California. Love a cake donut. So good. So good. So, but yeah, I need to be sponsored by Dunkin' through this trial because I'm going to have some donuts and some breakfast sandwiches and we're going to be eating breakfast sandwiches throughout this trial some days while I'm on stream because, well, they're going to start at 9. So we're going to be starting early, like early. Medicated Moment asked if they ever tried to move jurisdiction. I don't think they tried to move jurisdiction. I think the defense, and this is purely speculation on my part, I think the defense wants a local jury. And if I was the defense, I would want a local jury. I think they tried to change judges. They made motions to eat the judge. It didn't work. But I would want a local jury. Here's why. I want to know what you guys think about this in the chat. Here's why I want a local jury. Especially if you live in Massachusetts, are you mad? Like, are you mad about this case? Are you pissed off? If you're sitting there being like, what did you just say the police department that my tax dollars pay for is doing? What the fuck? Also, you need a jury that's just like, yeah, cops, if this goes on locally, and it seems with the amount of drinking and driving by law enforcement that this is shit that nobody deals with, based on everything that came up in this case, looking at it, you need people locally to be like, yeah, that's how I thought that was. That's not cool. That's not cool. That should not be happening. So all the cops are drinking and driving and everybody's just cool. No, fuck that shit. And a local jury is more likely to be frustrated, and especially local that understands a smaller town, that's going to be like, of course they're all doing that. Of course they're all doing that. And of course they are. And of course they think it's fine. And of course they think they're not going to get caught. Of course you need a local jury. So I think that there's a reason they wanted to change judges and not change locations. I think the defense feels that if they can show a jury what's going on, that the jury will get it. And I think a lot of the jury did last time. And I think the attitudes of local jurors are something that very much need to be considered. And like, rules for thee, not for me, or whatever, is infuriating. The amount of drinking and driving is so annoying in this case. It's just, what are y'all doing? And I think a local jury is really on point for that. It's going to be harder to pick one this time, but I think it's on point for that. So that was a great question, Medicated Moment. I'm glad we got to chat about it. Joe asked, if you were the Brennan to this retrial, what would you do differently from what Brennan has done so far? It's hard for me to put myself in this position because I wouldn't prosecute this case. So that's where I start from. I wouldn't prosecute this case. So where would I be as Brennan? Not prosecuting this case. If there was a way that somebody could convince me that count 2 was viable for some reason that I have not yet seen, I would have focused on count 2. But no, I wouldn't. What? No. So that's what I would have done differently, as a big no. But this case never should have been prosecuted beyond count 2. And I think there were misdemeanors within count 2 that maybe should have been considered. So yeah, no, I don't know what continues to push the Commonwealth forward. I was hoping to see it in the first trial and I did not. So if somebody can show it to me, I'd love to see it. I don't know why they elevated the charges. I don't know. Ashley McQuirk said Boston Rob reference on Abbott Elementary this week. Go watch. I will. I'm behind on things. Is Boston Rob going to be on Survivor 50? Also, no. I just, Tracy, thank you for the 10 gifted memberships. I appreciate you. Live, laughed. No. This is a terrible plan. 47, and I just began looking into adult ballet lessons. That is the greatest. I have a friend who teaches adult ballet to mostly individuals that have never done ballet. I think there is a beauty of learning new things as an adult. I think it's really healthy for our brain, and I love it. Dark Beholder said Survivor 50, there are that many seasons now. Maria G said, EDB, if Karen Reed is acquitted, can John O'Keefe's family sue her like in the OJ case? They are already suing her. I covered it ages ago. We haven't circled back to it, but the O'Keefe estate and members of the family are already suing her. So that. All right, Law Nerds. It is time. Thank you for being here. Thank you for hanging out with me for 2 different hearings and 2 different orders. We're going to try to go through the rest of the orders on probably on Thursday. And then next week, we're going to shift into a full week of Kohberger stuff. So we're caught up before Kohberger starts trial in August. It's going to be busy. And we will get to opening statements in this case when we get to, and we will cover other cases in the meantime. There's lots to catch up in the Corey Richins case as well. It's going to be a lot of criminal cases that we're going to be covering on stream. I will try to touch in on the civil cases on the Emily Show every Monday when I have time. The difficult thing for me truly has been the amount of reading in some of those filings to keep up with all of the cases we're trying to keep up with. And I do all that research. Why? Because I'm picky. I do all the research. And so if I'm summarizing something, I do all of that myself. And there is only so much time in the day. So I get a little bit behind when things get too busy, and lawyers can't chill on 100+ page filings. So, when is the Richins trial going? It's supposed to start in early May. We're going to have to figure out how, to balance the two. It might be that just goes right after this one. So, Kimberly said, what are we doing tomorrow? Members only live tomorrow, but I've got, doctor's stuff with the kiddos. So I'm not going to be available at regular stream time. Members only will be after 1 p.m. Central. So afternoon, but not evening. And I will see you guys on stream everybody Thursday. Members, I'll see you tomorrow. We've got lots to do. So let's roll the outro. Take care of yourselves. Take care of each other. Thanks for being a Law Nerd. Get the app. Do the things. See you in court soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.